Very good morning, man. My lord, item number 21. So for hearing, my lord, I got some information from my client. It was out of 17. Some were discharged because they are the daily wages.
Okay.
They filed a representation, they are re-engaging. So I need some accommodation.
Item 17,
21.
21.
I took the consent from the opposite side also.
You are for the
Petitioner.
as prayed for by Mr.
Sipal.
R.C. Paul, learned counsel appearing for the writ petitioner with consent from the other side, relist on such and such date.
My
Give a
lord,
date.
second week of September.
Yes.
On 10th September.
10 September, March, April.
19, 22, 25 and 26, my lords.
19.
22, 25
Yes.
and 26.
Advance slip was also
Yes,
given.
yes, given, my lord.
They are all same.
Yes, my lord. Issue is dismissal, but
19.
22,
They are all tagged.
25 and 26 are tagged. 20, 19 and 22 are not.
So 19 beleke diba, 22 beleke diba, and then 25 and 26 together. As prayed for by Mr. D. Gogoi, learned
And the petitioner.
learned counsel appearing for the writ petitioner by circulating advance adjournment slip with consent from the other side, relist
2 weeks, my lord.
after 2 weeks on a date to be fixed by the registry. But actually a date should be given. It's a whole
Yes, I
matter.
understand, hearing matter.
Give a date after 2 weeks on such and such date.
On 9th. My lords.
Okay, please, sure, sir. Lordship, I beg to mention item number 23, Lordship.
Yes.
We need some time to ascertain the correctness of the information, whether the petitioner is still alive or not, Lordship.
Your name?
S. Sharma on behalf of AK Protester.
You are for the petitioner.
Yes, Lord.
Item 20,
23, Lordship.
23.
Yes, Lord.
In item 23, as prayed for by Mr.
S. Sharma.
S. Sharma on behalf of Mr. A. Prakashta, the matter stands adjourned to such and such date to enable the petitioner to obtain instruction from the petitioner as whether the matter is still surviving or not. Did
Oh, bless you.
Please, my lords. I beg to mention, my lords, item number 20 of today's list, my lords. Lords, we have taken concern and circulated.
Yes, yes. Mr. Rajat
R. Chauhan.
R.
Chauhan, my lord.
Chauhan. As prayed for by Mr. R. Chauhan, learned counsel appearing for the writ petitioner by circulating advance adjournment slip with consent from the other side, relist on such and such date. When?
15th or 16th of September. Much obliged.
Yes.
May I please, Your Lordship?
I think for as far as hearing is concerned, I think enough adjournment has already been given. Otherwise, I shall have no work.
May I please, Your Lordship? I beg to mention item number 2, Your Lordship. The matter may be passed over for the day.
2 is from that referral list.
Yes, Your Lordship.
Wait for some time.
Your Lordship, my senior is unable to come today, Your Lordship, due to waterlogging.
But Miss Counsel, just wait for some time. I shall not pass any order that prejudices the interest of your senior.
Oh.
Yes.
To further to the other side, my lord, I beg to mention item number 30, my lord.
30.
On behalf of DK Das, my lord.
30 is a hearing matter.
Admission matter, my lord.
In the supplementary. Yes.
Matter has already been substantially hard, Lordship. Today is fixed for filing of compilation, Lordship.
Oh, that matter.
Lordship.
Okay, as prayed for on behalf of Mr. BK Das,
DK Das.
learned, by learned, your name as
AK
prayed
Das, my
for.
lord.
So and so on behalf of so and so, relist on such and such date. Give a date. Yes.
On 17th.
Bless you.
Yes, please call the list.
For reference to mediation, item number 1.
Agreeable, not agreeable, or instructions?
No, agreeable.
Agreeable. Likh it. Please give your appearance slips, okay? Because a copy will be given to all the councils. So just give your names, please.
Deeply blessed.
Item 2.
Agreeable, not agreeable, agreeable. Good. Names, huh?
Yeah, Lord.
Yes.
3.
Agreeable.
Perfect.
Other side, 3.
Item 3.
Government, AG, Agriculture?
Agriculture.
Agreeable? Very well. Please give your names, huh?
Yes, Lord.
Otherwise, you will not get the copy, then you will not know on which date you need to, your
Yes.
clients needs to appear before the mediation center.
Lordship.
All right, yes. This has come for the second time. Agreeable?
Not agreeable, my lord.
Not agreeable?
It is a completed already, so it can be gone for admission hearing.
Okay. That Lekham, heard Mr.
SP Sharma, my lord.
SP Sharma, learned counsel appearing for the petitioner, also heard MS Arbora and so and so learned counsels appearing for the respective respondents. Mr. So and so learned counsel petitioner. This matter being posted today to enable the respective counsels to obtain instructions as their clients are agreeable to have this matter settled through the mediation center. Stop. However, today when the matter is called, Mr. So and so, not agreeable or Hekini Didi.
My lord, may I just pray for a date because in 2020.
It will come, Mr. Counsel. We tried to sort it out. You are not agreeing. Yes, next. Second time, this also has come. Where is Mr. RP Sharma? Call it after some time. Mr. Bhattacharjee, just wait for some time. If you can get hold of someone, RP Sharma, I think, is the counsel. At least we'll know what has happened. From your side, I'm sure you're agreeable. Yes.
Item 6.
Yes, agreeable.
Lordship, no, not agreeable.
Not agreeable. Why?
So he wants to contest it.
This is not agreeable. Huh? All right, next.
Item 7.
Petitioner Namat Koba. Not agreeable. Yes,
Yes, my lord, agreeable.
agreeable.
Wants
Very
to take
good.
his son, 6.
Of course, that is the whole idea. You see, why should this court, in fact, bring out all these mediation drives? It is only to give a chance.
Exactly. Let's
This-
take
this-
a chance.
Absolutely, it's a win-win. You don't have anything to lose.
Yeah.
In fact, you will gain if the matters get sorted, right? Yes. This court appreciates such, from the bar also, such cooperations. Yes.
Much obliged.
Item 8.
Agreeable.
Agreeable?
Yes.
All right. Yes.
Item 9.
You will get the orders, but please give your names, huh? Yes. Yes, ma'am.
Lordship needs some time.
Instruction?
Yes, Lordship.
All right, instruction. You also in the meantime, I'm sure from your side you'll be agreeable. Should I record that? For respondent, your name?
I am on behalf of Standing Council of Animal Husbandry.
So said they are agreeable. For petitioner, instructions.
Item 10.
Yes, 10, agreeable, not agreeable.
My senior is for the time being.
Time being.
Yes, Lordship. My senior is.
Why are you not competent to say whether you're agreeable or you're not agreeable? Why do you need your senior to say that? If you do not say now, when will you say?
Lordship.
These are the opportunities.
Yes,
You just have to utter one word.
Lordship. Yes, yes.
Agreeable, not agreeable, or instructions. That's it. And you want your senior to come and address the court.
Yes, we are agreeable, Lordship.
Agreeable? Very well. Yes.
One problem.
What is the problem, Mr. Bora?
Yes.
Why should the state have a problem
Your lordship.
for attempting the matters to be settled through mediation?
Advocate who should actually represent Goalpara Municipal Board. We cannot actually represent Goalpara Municipal Board.
So who is the advocate?
I don't know, your lordship. They have to.
No, please.
Miss M. Bhattacharjee.
She is, I think, in
Yes,
bereavement.
so that's why after Monday.
Okay, this then we will have it. But then you are agreeable?
Yes, then your lordship.
It's agreeable. So anyone appears from Miss Bhattacharjee, any junior, please get hold of her name. Huh? You Sharma, na? And turn naam to Luluba. Agreeable. All right.
For admission, item number 11.
May I please, your lordship? Lordship, conducting counsel Mrs. Anseke is on legs in court number 9. Can it be taken up for some time, my lord?
Okay.
Lordship,
can it be
at 2 year or so?
Sorry?
Can it be at 2
No, let it be after some time. Why?
I have some other letter, your lordship, that's.
Okay, then Monday.
Lords.
Monday.
Briefly.
Deeply obliged.
May I please, the Lordship. Lordship, in the last occasion, Lordship.
Instructions were called.
Yes, Lord.
Mr. Shutia was supposed to,
Lordship,
yes, Mr.
the instruction.
Upadhyaya,
Lordship.
yes. You have the instructions?
Lordship, I don't have the instruction, Lordship.
Why?
Lordship, in fact, Lordship, we are sending it to the accountant general, the proposal, Lordship. So
Accountant General, Mr. Bhattacharjee is still there?
I'm here.
You are for Accountant General? Yes, have you received it?
No, we are sending it, Lordship.
You are sending.
Lordship.
Lordship.
We have sent it, but we are resending it, Lordship.
Lordship, in
Why are you resending again?
Lordship, some clarifications or short for.
So within how much time do you think this matter can be sorted?
1 week, we are sending it to the AG.
Lordship, this keep time, Lordship. They are
If,
sending.
if you send it in 1 week,
Lord.
how much time does the AG needs to?
Another 1 week, maybe, Lordship.
So I will dispose it of giving one week to both of you
Lordship.
with an upper limit of
But
3
subject
weeks.
to Lordship, the instruction received by the Lordship, my friend Lordship.
Huh?
Shutia Lordship. Subject to his instruction.
What do you mean by subject to?
His
You simply,
instruction is required because whether he is entitled for a compassionate pension or not. Lordship. This is the
but you have said you are sending it.
we are sending it, Lordship, now.
Now, if he is not entitled, then why are you sending it?
Lordship, we have to send. Lordship, the AG will decide, Lordship.
AG will decide.
Yes, Lordship. Whether he is.
We needed some clarification from the department. That's why we had recent.
So those clarification are now being sent to, they are saying it's going to be sent to.
We will
So
send.
then, you see, can this be disposed of in this manner that the clarification sought from the AG is said to be is said will be resent within a period of 1 week.
Lordship.
So after the AG receives it,
Lordship.
within a period of 2 weeks from receipt, they will do the needful in accordance with law.
Lordship.
Lordship,
Lordship.
Lordship, one more submission is, law is very much clear, Lordship. There's since Lordship several occasions, this is fifth time they are submitting the proposal. Lordship, law is very much clear. Whatever their instructions sought, I do not understand. Law is very much clear.
Now, if
she is clear.
you don't want a disposal, then I am adjourning the matter.
No, Lordship, I am.
What do you want? Tell me. Do you want the matter to be disposed or you want the matter to be disposed? Because I am not going into the merit, because since they are asking for clarification, as of now, they have not disputed your claim. They are not saying, but they are entitled for seeking clarification.
Okay, Lordship.
How can you say we will not give you any clarification?
Lordship, as because last.
So whatever, let them have their clarification. After that, they don't pay, then it's a different thing.
Okay.
Heard, Mr.
I have.
I,
Have.
Hawk Learned Counsel appearing for the petitioner, also heard Mr. N. Upadhyaya Learned Counsel appearing for
1 and 5.
respondent number 1 and 5. And Mr. A. Borwa, respondent number 4, and D. Bora for 3, Chalia for 2. So AG is R4. And Upadhyaya, you are for 1 and 5.
1 and 5, Lordship.
By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking grant of compassionate family pension to the petitioner pursuant to the Compassionate Family Pension Scheme of 2017 from 3/11/2019 to 1/1/2022. Inter alia, huh? Now, where is that clarification by which letter? Sure. Before adverting to the merit of the issue, pertinent that on 28/4/2025, a submission on behalf of the Learned Standing Council, AG ANE, within bracket respondent number 4, was made before this court to the effect that the grievance of the writ petitioner has already been substantially redressed and the amount has also been released. However, there is a small clarification which is required in this case as regards the entitlement of unmarried dependent daughters pertaining to Compassionate Family Pension CFP scheme, and as soon as such clarification is called for from the parent department is received, the matter will be dealt with conclusively. Or the order dated 28/4/2025 reads as under, quote unquote. You'll get it here, huh? Do it. It appears that in terms of the aforesaid order, which is the department? The irrigation. The concerned irrigation department within bracket respondent number 1 and 5 was required to furnish its reply in response to the said communication dated 26/3/2025 issued by the senior AAC's officer, Office of the AG, A&E Assam, within 3 weeks from 28/4/2025. Today, when the matter is called, Mr. N. Upadhyaya, Learned Counsel, appearing for the respondent numbers 1 and 5, submits that the aforesaid clarification, the required clarification shall be sent within a period of 1 week from today. Mr. So-and-so submits that after receiving the clarification as called for, the respondent number 4 shall do the needful within a period of 2 weeks from receipt of the same. In view of the aforesaid categorical endorsements made by the learned counsels appearing for the parties, this court is of the view that the instant writ petition can be disposed of in the interest of justice by directing the respondent number 1 and 5 to furnish the clarifications as called for from respondent number 4 within a period of 1 week from today, and upon receipt of the same, respondent numbers 1 and 5 shall do the needful in accordance with law.
Lordship.
I think that should be sufficient.
Lordship, I think matter may be keeping pending.
It is needless to be clarified that in the event it is needless to be clarified that since the matter pertains to compassionate family pension pending for several years, the respondent in their respective departments shall adhere strictly to the time frame provided and give to the time frame committed by them, based on which the aforesaid direction has been issued, failing which the concerned officer failing which contempt proceedings against the concerned officers shall be initiated in accordance with law. You need anything more?
Lordship,
Disposed of.
Lordship, one more thing, Lordship.
Hmm.
Here in this Lordship, there's some pension, is family pension is still remain, Lordship, it is standing. Lordship, my prayer is that after when this supernation, date of supernations, thereafter, Lordship, it becomes the family.
That is the difference. Let you
No,
first.
no,
This
no.
is your main prayer.
No, Lordship, what happened in this is from 3/4/2024, the pension is started, family pension. So, Lordship, that the gap period is there. So that period,
It is needless to be also clarified that the grievance of the petitioner as regards
family pension.
family pension shall also be taken into account by the concerned departments, and the same shall also be dealt in accordance with law within 3 weeks from today, from date of receipt of the certified copy of the order.
All right.
Highly obvious.
Item 13.
Lordship, here I have received an instruction. In regard to the claim of the.
Instruction.
Yes, please.
In regard to the claim of the petition, an inquiry was conducted, Lordship.
Yes.
And during the inquiry, if your Lordship kindly see the statement of the petitioner, Lordship.
What is this issue 13? Area salary?
Yes. Period from 12 to 19. The
Yes,
first page,
Oh my God.
first page at the bottom, Lordship. The statement.
Page?
First page of my instruction.
Oh, this instruction.
Lordship.
Yes.
Statement. Abdul Safid Mia is the petitioner.
Yes.
Now, Lordship. Lordship sees that statement. Petitioner simply stated that during that inquiry, Lordship, that when he was working as so and so, a fund of for construction of work was allotted in the name of the school. But some amount were spent in construction work, whereas rupees 5,34,844 is still with him after retirement also, Lord. He retired in the month of January 2019. This inquiry was conducted on 23rd of May 2025. So this amount of rupees 5,34,000 was with him. And
You have not filed your counter affidavit.
we will file.
Why have you not filed?
We have received the instruction today.
So you file it.
Lots we will file.
This is a 23 matter.
Lots.
Let them put this on record. Otherwise, how will he know you want to take him by surprise?
Lots. No, lots.
Heard Mr. Ajed Ahmed, Learned Counsel for the petitioner. Also heard Mr.
PN Sharma.
So and so Learned Counsel appearing for for Elementary Education Department. Standing Counsel Corridor. Chalia, are you there? A Chalia for Finance. And Mr. So and so, Standing Counsel Elementary, submits that he has received instructions in the matter and 6 for placing the same by way of an affidavit. 6 a short adjournment liquid by accommodation. Relist after 2 weeks on a date to be fixed by the registry. Withholding.
Lordship, this petition is not even maintainable, Lordship. 2014, Lordship, his appeal was dismissed. Now he's come to the court after.
So you don't wish to
Yes.
file any objection to the maintainability or your,
Lordship, on the last
because
of this-
it appears that no
Yes.
affidavit has come on behalf
Lordship,
of
we'll
the,
file an affidavit regarding the.
why don't
maintainability.
you file it?
Lordship,
Once you file it, you see,
Yes,
there is
Lordship.
some process of, you don't simply dismiss it on the basis of a submission, right?
Yes, Lordship.
If whatever
Lordship,
objection you have, you put it on record.
Yes,
The
Lordship.
petitioner has a right to reply.
Yes.
Yes.
1 week's time, Lordship. we'll file it.
Heard Mr. Abjad Majumdar, Learned Counsel for the writ petitioner. Also heard MS.
U Sharma.
U Sharma, Learned Counsel appearing for the respondents. MS so and so seeks 1 week time, 2 weeks time. No, you were all prepared to argue today. Why 2 weeks? 2 weeks time to file return in the matter. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
Lordship, one more prayer, because they are questioning the maintainability. First, it may be decided that.
You see, first let the return come, Mr. Counsel.
Sir,
Yes.
Lordship, I'm just on the date. I'm praying for a date.
Next.
Item 15.
Nice, Lordship.
Yeah, I'll pray for 2 weeks time.
2 weeks, file reply.
Lordship.
2nd September, man.
Hmm?
2nd September.
Okay. As prayed for by Mr. So-and-so, Learned Counsel appearing for the Standing Counsel, Elementary Education Department, relist after 2 weeks to enable the so-and-so to file return in the matter.
2nd September, man, the procedure.
2 weeks or date deduct, second যদি হয়।
Much obliged.
Item number 16. 16 and 17.
Here also, I think return, na, Mr. Manan? Has the return been filed?
No, they have not filed that.
Yes, Mr. Fukan, are you planning to file or you're going, or otherwise I'll foreclose it?
No, Lordship, I've received instructions, my lord.
You have received?
My lord.
You have received?
Yes, ma'am. We'll be
Okay.
filing an affidavit, my lord, sometime may be given.
All right. Heard Mr. Y.S. Manan, Learned Counsel for the petitioner. Also heard Mr. A. Fukan, Learned Counsel appearing for respondent numbers.
My lord,
So and so.
One.
Chalya?
1 and 2. One and 2.
1 and 2 Fukan, Chalya 4.
Five.
4. Mr. Fukan so and so submits that he has received instruction in the matter.
No, he's for 1, 2 and 3.
1, 2 and 3. Submits that he has received instructions in the matter and accordingly seeks a short accommodation for filing the return. Prayer is allowed, relist after 2 weeks
2 weeks.
or a date to be fixed by the registry to enable the respondents file return in the matter. Chalya also, if you want to file, you file.
Treasury officer.
Treasury need not file.
Lordship, the second matter, item 17, same,
Same? Okay.
same order. Much of.
Mr. Fukan, you received instruction in 17 or not?
It will be common, madam.
Okay. Whatever, I have said you have received. That is why on the next day, don't come and say you don't have instructions.
I'll file.
All right, Mr. Manan.
For orders, item number 18. Clerk,
Yes, why is this in orders?
in this case, I think my lord, respondent number 7 till that not appeared.
Not appear.
Eight.
You are for?
Lordship, respondent number 7.
Oh, he is appearing.
Yes.
So then 7 stands complete.
8 also complete, then I have gone through.
Who is for 8? Because the last order says the respondent number 7 and 8 represented by MK Sharma.
Lordship, we are for 8.
7 and 8.
Yes, he's for 8.
Yes, sir.
Both
7 and 8.
7 and 8.
7 or 8.
Seven, no,
Yes.
madam.
And
7 and 8.
Okay.
and the rest of the respondents, Fukan, you are appearing.
I'm looking for the elementary education.
They are for 1,
1 to 4.
1. So all are.
All are repairable.
What about 5, 6?
5, 6. 5 and 6.
5 also, I think, elementary.
Elementary.
No, 5 and 6 also.
So-
Madam, only 5, madam. 6 is
Member
the,
secretary, school management.
that is
committee
that will be
represented by
private,
headmaster.
madam.
So who is appearing for 6?
6 will be private, madam. Private.
6 is not appear.
6 is private respondent, madam.
No, I understood. But before I say service complete, I have to be satisfied. That is why I'm asking. So I think 6 is still not
Yes.
represented.
Not represented.
Now, what does the notice for 6 says?
In this case, my lord, 6 presence appearance of the 6 also not necessary also.
Mr. Counsel, this court made 6 a party or you made them a party?
I have made them.
So if you make a party, we will assume that their presence is necessary. That's why you made a
Member
party.
secretary, management.
No,
committee
don't
represented-
come make such
Oh,
submissions before
no.
this court.
6 is the represented by headmaster. 6 and 7 is the same person.
Mr. Sharma,
6
you are
and 7 is
Sharma?
Same person.
Mr. Das, please find out if you can also appear for 6 because then I can say it is.
Member secretary, school management committee represented by headmaster. my lord.
So you'll appear for 6 also,
Headmaster itself.
Yes, sir.
right? Okay. Heard Mr.
एक है sir.
So and so learned counsel for the petitioner, also heard Mr. A. Fukan, learned counsel is appearing for respondent number 1 to 5.
5.
Mr.
G does.
G, na? G Das, learned counsel, enters appearance for respondent number 6, 7, and 8. The respondent seeks. No, I think Mr. Fukan, you have already filed your affidavit.
Yes.
Yes, yes.
Mr. Das, so and so seeks how much time? 2 weeks?
Weeks.
1 week? 6 weeks time to file return in the matter. Prayer is allowed, relist after a week on a date to be fixed by the registry.
Any date may be given. Yes.
3, Mr. Fukan said.
3 also. No, 3 she can appear. She's there.
For 3,
After 1 week, 1 date may be given because I have
three.
already filed. That date,
give it.
date, my lord.
Giving, have
Yes, yes,
patience.
Deeply aware.
29. What's the place, my lord? For hearing, item number 24.
May I please, Lordship? It's a removal matter, Lordship. Lordship,
Where is the counsel for petitioner? Hmm? 1, 2, 3, 4, 5 counsels are there. I think this on the last occasion, a submission was made on behalf of the petitioner that some decision in Constable Pinku so and so 2017 5 JLR covers this case. And Ms. Gayan, CGC had sought time.
Can it be fixed on Tuesday, Lordship?
Why?
Because my senior Ms. A guy is out of station, Lordship.
But it is only for that.
Just 2 days, Lordship.
None appears for the petitioner on call. MS P. Rao, Learned Counsel, appearing on behalf of Ms. A. Gayan, Learned CGC, seeks accommodation for the day as Ms. Gayan, who is handling the brief for the respondent, is out of station. A perusal of the last order, dated 5/6/2025, indicates that a submission on behalf of the petitioner was made to the effect that the judgment in order of this court in the case of Constable Pinku Kumar Paul versus Union of India, reported in 2012 5 GLR at page 860, squarely covers the case of the petitioner herein. However, Accordingly, MS Gayan sought some time to go through the same and apprise the court court accordingly on the next date of listing. Since accommodation on behalf of so and so is being sought only for the day, this court allows the prayer and repose the matter on
Tuesday, Lordship.
Tuesday, such and such date.
Item 27.
Yes, please.
Lordship, this writ petition has been filed against a penalty order wherein I have been dismissed from service. Just give a brief facts. Lordship, in this case, I am challenging the penalty order on two grounds. First, in this whole episode, there are three officers, one sanctioning officer, one controlling officer, and I. Absolutely similar charge. The other two have been given much lesser punishment, and I have given the highest punishment. I'll show from record. That's one. So I'll first try to satisfy your lordship on the first plan.
So your challenge is only on the proportionality of the punishment.
And also, if I fail on that aspect, then I can show on record about the perversity. Both ground I have.
Strangely, you are arguing it
The reverse.
the reverse.
Yes, because
Huh?
why? I'm lordship.
That means you are giving an impression to the court that maybe the second ground of perversity perhaps is a very weak ground.
No, lordship. It's not.
No, because then I'm sure Mr. Pachwari is smiling from behind.
Lordship, what has happened, Lordship, to be very honest, Lordship,
Yes.
is a voluminous thing. Here, every record is. So, I'm being very honest. Here, what has happened is that right now he has been given the highest.
So therefore, there is some evidence. That
there
is why it is difficult to say absolutely that this is a case of perversity. Because if there is some evidence, of course, this
Yes,
court cannot go into it. This court is not correct.
obviously, also, there is
This-
some evidence.
Absolutely.
There is
So
some
this court
evidence.
cannot go into the this
The-
correct
It is. It's a
because this
perverse-
court is not the appellate court.
Yes.
Correct.
There is no dispute. Because
What about the procedural?
there is nothing.
Everything is
Yes,
followed.
there we are not on the right. Because
So
what has happened?
principles of natural justice followed.
What has happened? is that
And
with the-
there is no, you're not arguing on biasness and
No,
all that.
Nothing. But and what
So
has happened?
two grounds basically, one proportionality, and you also would like to show that the inquiry officer's proceedings is perverse. Correct? These two things.
Yes, because there is also one aspect to it. Though the charge is one, they have divided the charge into 16 sub-allegations. Now, for some, I have to admit, for some, there is some kind of an evidence which this honorable court may not be able to look into it. But for others, there are no evidence. So if the totality is looked into it, whether such kind of a punishment could have been given,
That is not for this court to go into it.
That's why Lordship, if Lordship takes the charge sheet just for a moment, just to understand.
Mr. Counsel, you have the whole day. It's a hearing matter. And going by the volume of the brief, please feel free to argue in the manner you have prepared.
Lordship.
Yes.
Lordship, I'll just show all the charges of all the three. I had prepared, Lordship, I had made some on the last occasion, I had argued this matter at length, but it was released from part, but that's a different. So this is a compilation. It's already there in the record, if I'm not wrong. Because everything has been provided on the earlier occasion. I think that's Lordship is.
These are the order sheets.
Lordship, if I can see the file one.
Yes, please.
Just to.
এটা দিদিয়ক তেওঁ উলিয়াই দিব এইখিনি দিদিয়ক গোটেইখিনি দিদিয়ক you can just sort it out.
I just.
You be there, they'll bring it to you. লৈ যাওক Kamal.
Judgment probably are not.
If you are carrying a copy of the judgments, okay. If you don't have it, you give the list. In the meantime, they will try and get it from the library.
This top file may be taken.
A judgments cycle.
Lordship, this compilation.
Yes.
This compilation.
Which says charge sheet.
These are the charge sheet. Now, Lordship, first I'll show the charge sheet of the topmost official. No, আপনি আনাই দিয়ক মোৰ এটা কপি আছে
এইখিনি আনাই দিয়ক
Lordship, page 2. There are three persons: Asapurna Singh, Bhaskar Datta, and Sunil Mishra. Sunil Mishra is the applicant, is the petitioner here. Page 2 is Asapurna Singh, the topmost.
Ashapurna Singh.
Lordship has got it.
Yes, he's the
No, the topmost. In the whole transaction that had happened. So this is the allegation. May I read, Lordship?
No, who is the petitioner?
Petitioner is Sunil Kumar Mishra. I'll come to Sunil Kumar Mishra. I'll just want to.
No, just if one, please. I'm sure all the names figures out. Which is that page? It doesn't figure out.
No, because they all separate inquiries happen.
Okay. All right.
First page 2.
Yes.
During your tenure as chief manager at Dadara branch from 19/9/2017 to till date, certain serious irregularities were alleged to have committed by you, and due to your such irregular activities, the bank is exposed to suffer a pecuniary loss to the tune of 205.31 lakhs besides reputational loss. Pausing here, Lordship, this is the main charge is 205.31 lakhs besides reputational loss. This is the main charge. Then he says, you have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions. These acts are unbecoming of an officer. So basically, the most grievous, the most important part is that this officer it has been alleged that there is a pecuniary loss of 205.31 lakhs besides reputational loss. Now, Lordship may come to page 5. Now, as I had said, page 3, these are the various allegations. I'll not go right now to page 5 is the last allegation. Allegation number 10, Lordship has got it.
Yes.
That you did not discharge your duties with utmost devotion and diligence and have jeopardized the interests of the bank. Due to your such activities, the bank is exposed to suffer a pecuniary loss to the tune of.
What is the exact allegation?
This is the exact allegation.
What?
That there is a pecuniary loss of 205.
No, but for what? How did you make this loss?
This loss. This
you
allegation
must not have followed some particular norm.
This allegation 1, 2, 3, 4, 5, 6.
What are the in substance? What are these allegations? that you have not checked some KYC or
Yes, that is
something?
one, that is one.
What are those? Just tell me.
The first is that there are KCC loans, there is a circular where you have to ascertain the borrower at ATM things.
Mr. Counsel, you take your seat. Yes.
So the first is that the RuPay card, there is a RuPay card for KCC loan that as per the bank, you have not done in a proper way. So that is, there is,
As per?
as per the bank, you have not done in a proper way. There are 958.
Not done what proper way?
You have not verified, you have not ascertained the borrower, who the
Borrower.
is.
Yes.
So that is allegation.
And you are holding what post?
I am the field officer, the lowest.
Field office.
So a KCC loan, what happens is that the field officer comes with the information from the borrower. Then there is a sanctioning authority and there is a controlling authority.
So this is in respect of loan.
Loan, KCC loan.
ACC loan.
KCC loan.
KCC loan. Yes. Yes, please.
Then there was another aspect of Mudra loan.
Yes.
What they have done is that
35 Mudra loan.
Mudra loan. And there was another aspect wherein there was an allegation where this KCC again loans, some external persons are involved with the bank. I allowed those external persons to sit in the
No,
bank.
but where is your charge sheet?
That is page 40.
Let's come to your charge sheet.
Page 40.
Page
40.
40. You are Sunil Kumar Mishra.
Yes.
Yes, please read.
During your tenure as field officer at Dodora branch from October 2017 to August 2018, certain serious irregularities were alleged to have committed by you, and due to your such irregular activities, the bank is exposed to suffer a pecuniary loss to the tune of 205.31 lakhs besides reputational loss. Verbatim same.
Yes, please.
You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions. These acts are unbecoming of an officer. In this manner, you have violated 54 of the SBI Officer Services Rule that is applicable to you. Imputation of lapses on the basis of which the aforesaid charges are based are furnished in the Annexure 2, and the list of documents, witnesses on which the bank would rely upon to prove the charges are given in Annexure 3.
These officer service rules are available.
Yes.
Just keep it, okay? Rule 54.
Four.
We will come to it. Now, let us see the allegations.
Page 41.
Yes.
Allegation number 1. It is reported that 968 KCC loans were sanctioned at the branch on your recommendation during the period from October 2017 to August 2018. Out of 968 KCC loans, 927 loans were disbursed in cash by using withdrawal slips. As per
Slowly, Mr. Counsel.
As per circular, the KCC borrowers shall be issued an ATM-enabled KCC RuPay cards to enable them to conduct their banking business. You have recommended proposals without obtaining the required application forms for issuance of KCC card, resulting in disbursement of the proceeds of the loans in cash. Allegation number 2.
Yes.
You have obtained voter ID from many applicants and recommended the proposals for sanction without verifying and confirming the genuineness of the ID of the applicants. As example, list of 27 such applications are enclosed as Annexure 2. Allegation number 3.
Yes.
Signatures on PAN cards and SB account opening forms of the customers do not match with the signatures obtained in the KCC loans in respect of the account numbers. Example, such as these are the examples.
Yes.
Allegation number 4. Only one document obtained for ID and address proof is voter ID instead of 2 documents as per revised KCC Master Circular number sentences dated 9/3/2000.
So only one was taken.
Only one was taken.
Hmm.
But this charge has not been proved again, or not all charges have been proved. The list I will give.
No, allegation one is said to be proved.
Yes, the allegation, if I read first, then I'll give
No,
the.
just let me know.
Let-
I'll just take a note. Allegation one said to be proved or not proved or partially proved.
I'll just, if Lordship gives me 1 minute. Allegation one is proved.
What about two?
Allegation two is proved. 3 is partially proved.
4,
But 3 would be not proved.
3 is not proved.
Not proved.
4,
4 not proved.
5,
Not proved.
yes. 6, now
Six.
continue.
6 is proved.
Okay, just before we go that first, all right, let me write down and then we can read it. 6 is proved.
6 is proved.
7,
7 is proved.
8,
Not proved.
9,
Proved.
10,
Proved.
11,
Proved.
12,
Proved.
13,
Proved.
14,
Proved.
15,
Not proved. 15 is
pre-sanction survey.
pre-sanction. Partially proved.
Partially proved. No wonder your counterpart was standing up. Partially proved.
Partially proved.
Huh?
No, partially proved.
Proved or partially proved?
It's there. I'm not like talking from record. I'm not giving it.
You verify. You verify it
Page 60. You can see page 60.
because these are admitted facts. So
Sir, like it's
yes, there can be some time here and there because you see in saying so you just re-verify. I am only taking a note because I'm trying to understand the factual facts, right? So if there is something, you'll feel free to point out. Yes. What about the
16.
next one? 16?
16 is proved.
Okay. Now I'll continue reading the allegations.
Yeah.
I think we finished 4.
4. We finished
Yes.
4. Allegation 5.
Yes.
Out of the 968 ACC loans, 65 loans were not controlled by the appropriate authority. You did not take initiative for control of the same.
What does it mean?
Control means approval. In common terms of it. Allegation 6.
Yes.
You have allowed disbursement of many KCC loan amount to third parties other than borrowers. What it means that the borrower, I'm not the cashier of the bank, but I had allowed disbursement. So that's itself is that's why it was not proved if I'm not wrong. Anyway, in respect of 35 KCC loans disbursed during the period October 2017 to August 2018, first disbursement includes cost of post-harvest consumption and farm maintenance and insurance as per assessment made by you, violating extant instructions of the bank regarding disbursement of KCC loan component. Allegation 8. You have allowed recovery of AUCA from the proceeds of many KCC loans. Allegation 9. Out of the 968 KCC loans, 102 loans were not recommended for sanctioned or control, but the proceeds were disbursed to third party.
So without sanction. that
Without
means.
sanction, proceeds were disbursed. But again, whether I can disburse, because I am not the disbursing authority, it's to the cashier it goes. There's a cashier who gives the money. And I'll show the chart based on which this 205.
So during the evidence, your duties, your everything has come out. Like what are your as a field officer?
Everything.
Because you see, by the very term field officer, what comes to the mind of the court is that it is basically survey and verify,
So
right?
That's
And
my that's my work only.
that is probably the
That is the work.
So I'm sure these must be there somewhere.
Yes, I have stated.
And maybe this has also come in evidence.
Yes, and
where
that's why the other two officials also had their departmental proceedings started.
So they basically here now they have the allegations are against the field officer, cashier.
No, sanctioning authority and the controlling authority.
And what is the punishment awarded to the controlling authority?
The controlling authority as well as the sanctioning authority, they have been given the punishment of reduction to lower stage in the time scale of pay by one stage for 1 year, with further direction that the officers will not earn increment to pay during the period of such reduction, and on expiry of such period, the reduction will have the effect of postponing the future increments of his pay in terms of Rule 67F of such a.
And you?
I have been dismissed. That means I'll not get the PF.
You have been dismissed from service.
So yes,
So you have been given the maximum.
Maximum topmost. And Lordship may just see page 73. How they have assessed.
No, we will go all that. I'm just trying to clear it.
So that.
Anyway, let's finish this.
So we had read till allegation 8.
8.
Yes, 9.
7.
9 we had read. 10.
10.
10. You have closed 35 mudra loans from the proceeds of KCC loans in contravention to the bank's extant instruction. Allegation 11. You have debited 3,78,000 on 6/9/2018 and 15/6/2018 from your account number such and such, and again rupees 25,000 from your account number such and such, and credited the proceeds to account number such and such of Mr. Saddam Hussain, the recovery agent of the branch, without any bona fide reason. Allegation number 12. In connivance with Sri Saddam Hussain, the recovery agent, you allowed him to handle loan documents, application forms, as evident from the CCTV footage dated. These are the dates. So, allegation 12, you are married again?
Yes.
In connivance with Sri Saddam Hussain, the recovery agent, you allowed him to handle loan documents, application form, etc., as evident from CCTV footage dated such and such. These are the dates on which the CCTV footage of the bank, inside the bank. So, I had allowed the handling of documents. This is one of the allegations. Allegation number 13, next page 43. You have renewed 966 KCC loans during 2018 without physical verification and without obtaining borrower's consent. Allegation number 14. You have recommended for payment of commission on recovery of AUCA to Sri Saddam Hussain, the recovery agent, though actual AUCA recovery was not made, but proceeds of KCC disbursement was used as AUCA recovery. Allegation number 15. You have not done pre-sanction survey in respect of KCC loans to ascertain undisputed cultivation rights over the land, skill, experience, and capabilities of the applicants before recommending the applications for sanction. Allegation number 16. Thus, you have not discharged your duty with honesty, integrity, devotion, and diligence, and your such acts have jeopardized the interests of the bank. Due to your dishonest activities, the bank is exposed to suffer a pecuniary loss to the tune of 205.31 lakhs. This 205.31 lakhs, this has to come. Now, that cannot be an arbitrary figure. This has to, in all the cases, how they have come to that figure, I have annexed this document, which is exhibited. And this is page 73. Just for.
Can we go into all that?
No, just for, yes, because this is a purpose.
Let's go to the disciplinary proceeding now. Where is the inquiry proceeding?
Lordship, I'll show just for one moment if 73 is looked into it. Because I just want to show the perversity part, why it is so perverse. Page 73 of my compilation that I'm reading.
This compilation.
This year, the last page.
Yes,
This is an Excel sheet.
yes.
Based on this is 205. Based on this, everything has been.
Have you brought this in evidence?
This is their exhibit. Their
Now,
the
what do you want to show from here?
Lordship, a Excel sheet to determine the loss.
Mr. Counsel, how can this court go into all this?
Because of
Anyway, now let us go to the inquiry report.
of the delinquent.
Of course, we are concerned with the delinquent. We are not concerned with the other officers. That case is not before this court, right?
I am on the parity because the year I've been.
See, but this court has to first see your case. This court is concerned with your case.
Okay.
Now, just because in some other case something else has happened, suppose
Because it's the
you
same
see-
transaction.
Could be. But first of all, let us see what are the facts of your case. That will come at the end. When you are trying to convince the court the proportionality, then maybe that can also be one of the factor.
Lordship.
But of course, everything would depend on the gravement of the charge. The proportionality has to be proportionate
Yes, when the
to charge.
absolutely similar, then
See, charge could be absolutely similar. Now we don't know how they have proceeded because what is your role? Because you are the field officer. So let us see how. That is why I am repeatedly saying, let us see the evidence. Let us see the inquiry proceeding.
Lordship, I can we'll go through it's page 351. In the inquiry in the
Because
records,
otherwise, it appears that charges is quite serious. A lot of loss appears because you have not carried the survey without sanction.
no, that is not the. I'll show by here the charges. If the charges are, if all the loss has happened, that it has happened, all the three officers have to be given the same thing. If not the same thing,
Why have they not been given the same punishment, Mr. Counsel?
That's the where. And there is no inquiry report of the.
Why they have not?
All the three officers, Your Lordship, they are on a different footing. By the time the inquiry has been concluded, the petitioner has already retired from service. And there is a rule in the State Bank of India rules whereby, Your Lordship, even after the retirement of service, disciplinary proceeding can be continued. And at the end of the inquiry, Your Lordship, the penalty can be imposed. On the other two officers, Your Lordship, they are still in service and their rank has been reduced, Your Lordship.
No, but that is not the query of the court.
Lordship.
Now you have imposed the punishment of dismissal from service to the
Lordship.
petitioner, right?
Lordship.
Now he may have retired, but dismissal from service is one of your maximum penalty,
Lordship.
correct? Now, if the charges are same, in fact, he is only the field officer. The others are the controlling, the sanctioning. They are much higher. Their responsibility also becomes higher. Why have you not given them the same punishment? Why have you taken a lenient view towards them?
Lordship. The total allegations.
And is there any writ proceeding pending against those two people?
No, Lordship. There is no report. Your Lordship, the total allegations against the present petitioner is 16, out of which 12 allegations has been proved, Your Lordship.
What about the others?
Your Lordship, other Bhaskar Datta, who was the assistant branch manager at the relevant point of time, there were 9 allegations, 3 were proved. And to the other officer, Asapurna Singh, who was the chief manager, there were 10 allegations and 6 were proved. But Your Lordship, the involvement of the petitioner in this alleged fraud Your
Is
Lordship,
more grave. Is more grave. That's what you're saying. All right. Yes.
The reason that they did not give the difference of punishment is said that the officer was not aware of his duties. This is in the inquiry report of the officer.
Let's go to the inquiry report
Lordship 351
of the
paper book. In the voluminous thing.
paper book from here.
Yes, Lordship. It will be part 1A.
But why is it a data file there?
Because here I had given a separate, because being very voluminous.
No, but this is an I. It
No.
I nahi. Is it I also?
No, I had filed to bring on records the disciplinary proceeding things of the other two officers. So this, in this file, everything has been kept. My compilations and everything. This compilation is regarding the similarity of the allegation of charges.
এইখিনি বিচাৰি দিয়ক এইটোতো এইখিনি বেলেগ কৰি দিয়ক এটা আয়ে তো আয়েটো এইটো ডিছপ'জ আয়েটো বেলেগ বেলেগ পেপাৰটো ওলাই যাব পাৰে নহয় আপুনি মানে Yes, there are two volumes. Which
Yes.
one? The first
1A,
one,
1A,
1A.
page 351.
Page
351.
351. Was that there? Was that there? I will pull it over. Page
351.
351.
51.
Oh, that is, I think, the second volume.
Yes, 1A.
It's not marked. 351. Three 51 is the inquiry report.
Inquiry.
Right? Yes. Yes.
Starts from 353.
Yes, please.
Allegation number 1. I'll read again, Lordship.
Yes.
So that it is reported that 968 KCC loans were sanctioned at the branch on your recommendation during the period 2017 to 2018. Out of the 966 KCC loans, 968 KCC loans, 927 loans list enclosed as Annexure 1 were disbursed in cash using withdrawal slips. As per circular, KCC borrowers shall be used.
That's all right.
Yes.
This is the allegation we have already seen.
The presenting officer's brief.
LA's finding means the inquiry officers.
IA is inquiry authority.
So their finding, read
Their
finding.
Fine. I'll read the finding of the presenting officer.
Finding. You see, you have to understand that I am not reappreciating and appreciating all this. I am just trying to see in nutshell what is the finding of the eye. That's all.
And whether the IA actually considered the evidence, that also has to be.
I am not into all that. This is not the scope and ambit of a 226 code when it's taking up the inquiry proceedings.
If
The
an- if an
226
evidence-
code has the limitation when it comes to a disciplinary
Yes,
proceeding.
that I am aware.
I am
what-
not going to reappreciate and appreciate.
But the
Yes, perversity means no evidence, absolute no evidence. That is perversity.
Yes.
That is perversity, not otherwise.
For an evidence which has not been.
That is not,
If
I'm
there is
not
an
going to
evidence-
go into that because you see, this is not a court proceeding.
It's
This is
an
not a
appellate-
court
it's not an
proceeding.
appellate thing, because-
Here, basic thing is procedures, natural justice, principles of natural justice. Admittedly, everything is followed. There is no violation of principle of natural justice. There is no allegation of biasness.
No.
The inquiry must be fair
Yes.
and unbiased. Those are not there.
No.
Fairness is not challenged here.
No, Lordship.
So please understand, you
Yes.
are under a narrow encompass.
Yes, I'm.
Right. So in order to appreciate your argument for proportionality, I am only trying to see a little bit of the inquiry proceeding. I'm making myself very clear. Yes.
IS finding. As per circular number census, serial number 1 census dated 9/3/2017, submitted by the presiding officer as PX2 and circular number census dated 27/2018, submitted by the defense representative as DX3. Issue of ATM enabled KCC RuPay cards is mandatory to KCC account holders for conducting their transaction through alternate channels. CSO has not initiated any action to provide ATM-enabled RuPay cards to eligible KCC borrowers. The submission of DR that as per DX, the TAT in case of KCC loans is 3 days after all required formalities. Issuance of ATM card is also one of the formalities. The CSO has not obtained ATM application even after the generation of account number, leaving gaps in completing the required formalities. The CSO failed to follow the circular instructions of the bank.
Yes.
Then the second allegation, 355.
The not proved ones you don't have to read.
Okay.
Yes, second.
Then hence it is proved. Then
Second is proved.
second is proof.
Hmm.
355. The
Hmm.
presenting officers has verified 27 ID cards which are annexed as example with allegation number 2 through official internet site of the government and found that the records are not found. The PO is also stated that more than 300 such documents are available where ID card is not genuine. As argued by the defense representative quoting the physical copy of the official valid document to be compared with the original OVD and recorded the same. The CSO has recorded the verification of such OVDs in the loan documents. It is evident from the 27 examples where the issuance of voter ID cards are available at the government official site, which give self-explicit proof that these are non-existent and false KYC papers prepared by the borrower to defraud the bank. Prepared by the borrower. Thus, the CSO has failed.
Borrower, I understand, but you have failed to verify.
No, Lordship, how do I verify?
That is the allegation. I'm
That's
not
the-
now. You see, I'm not going to get into that area. I cannot.
Lordship,
Yes.
that's the. Thus, the CSO has failed to verify the genuineness of the OVDs and could not restrict the genuine borrowers from taking bank loans under the guise of false KYC papers.
Under the guise of false?
False KYC papers. Instructions on KYC compliance are important instructions of regulatory authority to identify genuine customers and to protect bank FI from the probable fraud, money laundering activities which the CSO has failed to comply. This is the second.
Yes.
Third is partially proved.
Yes. 357.
It's third should I read? It's partially proved.
All right.
Presenting officers produce CBS pen and signatures in loan documents in all 6 examples given by DA. Signature not tallied with the CBS signature in case of account number such and such, such and such, such and such. Other signatures are tallied in some documents. Hence, the allegation number 3 is partially proved. Then comes allegation number 4, which is not proved. I need not read, Lordship. Allegation number 5, not proved. Now, allegation number 6.
Page.
362.
Yes.
It is evident from the withdrawal slips that the KCC has been disbursed in cash to third parties. The CSO has given pay order to the SWO as per PW5. IW3 mentioned by PO erroneously. During giving pay order or passing CBSQ, it is the responsibility of the official to confirm that the payment is being authorized as per bank's laid down instruction. The DR has argued that nowhere the CEO has given any instruction to pay to the third party. As per submission of the PO, the CSO has authorized the payment to the system for payment and allowed for such cash payment of such withdrawal slips where the third party has signed. The CSO has failed to check KCC disbursement to third parties. Rather, he neglected the bank's instruction and allowed the SWO for payment. Now, this has to be correlated with the allegation. What is the allegation? The allegation says that you have allowed disbursement of many KCC loan to the third parties other than borrowers. I not being the cashier, can I allow that? A borrower, if they just by because the persons will go by withdrawal slips, or there has to be the bank officials has to verify and give the money just by my sign and a field officer, not even a sanctioning authority. And the language here is also not clear. They have said, okay, the IS finding, it is not clear. This is my submission. Next. is allegation number 7, 365. This proof. Prosecution officer, it is evident that in 35 KCC loans, the CSO has allowed disbursement of almost entire KCC limit during the first disbursement. The argument of the defense representative that the bank has no control to disburse KCC in stages is a statement away from truth and hence is not acceptable, as drawing power may be set in the system as per requirement. Release of funds in installment on phases is to ensure that the funds are utilized by the borrowers as per their need and requirement and to meet the purposes for which the loans have been sanctioned. As per the limit and withdrawal, it is evident that the CSO has violated the bank's master circular instructions placed at PX2 by prosecution officer in disbursement of KCC limit.
What is this violation actually?
Actually what had happened is that when KCC loans are there are various stages. They're before harvest, post harvest. So what they had alleged is that before harvest only every part was taken. Utilized. This was the kind of allegation. But the point again is it's the borrower's part which has come and done. Again, the sanctioning authority and the controlling authority is a person who has to look into it. If I'm not, I'll show later on about their sanctioning authority, what is the opinion of the inquiry officer. Then comes allegation 8, which is not proved. I'll not read. Then comes allegation 9, which is proved. As per the submission of the prosecution officer and evidence that in many cases recommending officials' signature, sanctioning authority signature, and controlling authority signatures are not found. As per defense
Signature are not found.
As per defense representative's argument that all loans are sanctioned through LOS. Despite the loan sanctioned through LOS, the signatures are required to be recorded in the loan documents which are generated from the LOS system for recommendation and sanction. Recording signature on the loan documents, even if these are generated through LOS, is not merely putting signatures on the loan documents. It goes to prove that the recommending officer has applied his fair mind and common sense from the viewpoint of the feasibility of the loan proposal and recommended accordingly for the sanction. The CSO has failed to meet the required formalities. This is the higher official's job. This is the point which the inquiring authority is saying, that you have to look at it's not the clear line said that it goes to prove that the recommending officer has applied his fair mind. So they have to apply the fair mind. They did not apply. I am being penalized.
According to you, you've been made a scapegoat
yes. In fact,
failures.
In the inquiry report, they have clearly said that he is new to it. He was not, the top official is new to it and he is not aware of the things. This is the presenting officer's brief in the inquiry report, it is said. And one official, there is no inquiry report. Out of the two, there is one official, there is no inquiry report on record.
No inquiry held.
They said inquiry held. There is no inquiry report. That can be verified and can be brought on record.
Which one?
Asapurna Singh, the top one.
That is the sanctioning.
The top controlling. So the top one did not. There is no inquiry report. Without inquiry report.
And top one is reduction of rank.
Both of them the same. One appealed, one did not appeal. The appellate order was passed. So this, and without inquiry report, apparently.
Did you file an appeal?
Yes, I filed it. It was dismissed. That's all. Then comes 378. This is the allegation number 10. Prosecution officer has submitted that PX5, where it is clearly evident that 35 mudra loans have been liquidated from the proceeds of KCC loans. The CSO failed to understand the difference between mudra loans and KCC loans. Mudra loans are meant to help. It should be help, I think. Help an entrepreneur to start a business. Activities to be financed.
Mudra loans are help and to start a business, basically.
Mudra loans are for business. So the line is the CSO failed to understand the difference between mudra loans and KCC loans. That
And
at best,
KCC is what?
Kisan credit card.
Credit card.
So-
That is for the agriculture.
Of the agriculture. Mudra is fine. Now, the line used by the inquiry officer that CSO failed to understand the difference between Mudra loans and KCC loan is clearly evident. It's at best a case where I am not able to understand the job properly, whether this kind of a punishment can be given. This is what has to be looked. The inquiry officer himself says he has failed to understand. So, not able to maintain, Lordship is aware that not able to maintain the highest standard cannot entail me to give this such.
According to you, what should have been the punishment?
Lordship the same as them, at most the same as them. Whatever is the punishment that they have given. So
Where do we get your charter of duties?
charters of duties is there is no specific thing as such in the bank also.
No, you have cross-examined?
Yes, I have cross-examined. I have these things are these are part of.
Now,
the,
what has come? Because what is your nature of?
Then I have to read the DR's representative whatever has in the.
No, you have that particular portion. Is it readily available? Because you see, if I have to interfere with the penalty part, the only way is to say that because of the other two getting that rank.
Yes.
Correct. I have to be mindful of what is the nature of your duty. Right. Now, how have they, as far as this, because in this writ petition, this is your allegation, one of your alleged ground. How have they countered that in their affidavit? What are they saying in the affidavit? What is their stand?
No, when this affidavit, they at that relevant point of time, when I filed this affidavit, the inquiry report was not out. But though in my writ petition, I had also brought in on record.
No, where do I get their stand as regards why they have given you this dismissal from service?
Lordship, to that, since there was a similar kind of a.
Because I find that you had given a representation at page 411.
411.
Isn't it? Where the inquiry come findings was given to you and for your comments.
Yes.
That you have given.
That I have given.
Then at page 425
is
the penalty.
Is the penalty.
Right. Please refer to the charge sheet upon due consideration of the records of the inquiry. I propose to impose the following penalty. Dismissal in terms of rules so and so. His suspension period so and so, forfeiture so and so. You are hereby called upon to appear before so and so. Or make submission as to why proposed penalty. So this is basically another notice by which they said after they have read the reply of your to the inquiry proceedings, right?
And I have given a reply on 429.
So this all shows that you have been clearly given all the opportunities. Yes, and you have correctly not assailed the same. Now, after this, which is the impugned order after page 425, your reply must have come.
Its impugned order is page P19.
Page
P19
P18 is your reply.
is my reply.
And page 432
432.
is the final penalty.
Final penalty.
Then you have filed an appeal.
Then I filed an appeal.
And that appeal was dismissed.
This appeal was dismissed.
Where do I
page
find
490,
that?
490.
490.
491, sorry. Sorry, I'm sorry. 491.
491, appeal dismissed.
Lordship may come to the appellate order at page 500. Page 500. The relevant portion.
500.
Yes.
Yes,
Our observation, Lordship, if I may read.
yes, please.
I have carefully, independently, and dispassionately examined the appeal of Sri Sunil Kumar Mishra against the order of punishment dated 29/11/2019, passed by the Disciplinary Authority and General Manager NW1. The statement of imputation of lapses and the submissions made in this regard by Sunil Kumar Mishra and all other papers relating to the investigation in its entirety, and my findings are as under. Mr. Mishra was under police custody from 14/10/2018 and was granted bail by the application number such and such dated 20/12/2018 after a long period of 68 days. Serious lapses, gross negligence, including obtaining fake documents, were observed during the processing of 968 KCC from October 2017 to August 2018. Out of 968 KCC loans, 971 KCC loans disbursed to third parties. 35 Mudra loans were closed from disbursement of KCC loans in contravention of bank's extant instruction. Serious lapses observed in renewal of KCC papers without proper verification and without obtaining borrower's consent. The letter number such and such dated 3/8/2009 has apparently no relevance in respect of transaction with Saddam Hussein. After considering overall circumstances of the case and the investigation inquiry report, I understand that the lapses committed by Sri Sunil Kumar Mishra were serious in nature. I do not find any merit in the appeal, and I feel that the punishment awarded by the Disciplinary Authority and the General Manager NW1 is proper and commensurate with the gravity seriousness of the lapses committed by the appellant.
All right.
I therefore,
So
Now-
as far pleadings and actions are concerned, these are the main ones, right? And after this, you have come before the
Yes.
court. Yes. Now, you wanted, what case laws you wanted to refer?
yes, I wanted to refer.
Or should we see the case laws at your reply? Because
Yes,
you can do that. Till then, you can just,
no, I already given the.
you have given. That part I would need from you, and also from the brief, anywhere you can point out your charter of duties. That part you can, if anything is available on record.
Lordship, will a statement from me in the will not happen? It has to be from them, unverified. So it will be the inquiry officer's part or the appellate.
So
part.
just check
just-
while, can I just take a 5 minutes break if
Lordship.
you permit?
No, Lordship,
Huh?
that will be very
5 minutes
5
break.
minutes, sir.
Okay.
Deeply obliged.
Cases of a fraud.
Huh?
Fraud of issuing loans, your lordship.
Fraud of issuing loans,
Loans,
yes.
your lordship. There's a fraud in issuing loans.
Yes.
And to give a picture, your lordship, if I may be allowed, this fraud has been unearthed by an official of the State Bank of India, a lady official. She has unearthed all the scam and all the fraud. However, after a few days, your lordship, she was shot to death on a broad daylight.
She was shot.
Shot death. And the persons involved in this assassination, your lordship, was one Saddam Hussein. Your lordship has got the name probably,
Hmm.
who was the recovery agent.
Hmm.
And he has direct connivance with the petitioner. Just to give a backdrop of the picture. your
That connivance is proved.
Your lordship, the trial is going on.
There is a criminal trial going on. So he is also
He was
the,
arrested but was released on bail.
I'm discharged. Just on record here, not.
No,
I'm
no.
discharged.
It's all right. You'll have a right to reply. You see, your name?
H. Buragohain, lordship.
Buragohain, huh? Mr. Buragohain didn't even say a word when you were
No,
submitting.
I'm sorry.
So
Well,
you have to respect each other's,
I'm sorry.
you know,
I'm lost. Sorry.
yes.
So this is the picture, your lordship, to show the seriousness of the offense. Now, your lordship, the
So
petitioner. has-
ultimately, that in that criminal case, the petitioner is acquitted,
Your lordship, discharged, your lordship.
discharged.
Initially, he was made this. Now, your lordship, the three grounds, your lordship, this has been raised by the petitioner is regarding the perversity, first ground. Second is the, your lordship, parity of this one punishment. Your lordship, three officers, your lordship, are on different footings. And as your lordship has pointed out, the role of the service of the petitioner, which has to be taken into account to find out the parity in the punishment, your lordship. The petitioner Sunil Mishra, your lordship, all total 16 allegations were raised, your lordship, out of which 12 allegations has stand proof. Bhaskar Datta, your lordship,
16 out of 16, 12
12
proof.
has been proved. Your lordship.
Yes.
Bhaskar Datta and the petitioner was the field officer.
Bhaskar Datta.
No, petitioner, your lordship, Sunil Kumar Mishra, he was the field officer.
So who is Bhaskar Datta?
Bhaskar Datta was the assistant branch manager
Okay,
at
so,
the relevant point
okay,
of
okay.
time.
Yes.
Against him, your lordship, 9 allegations were raised, and out of which 3 allegations stands. proved.
Bhaskar Datta.
Bhaskar Datta.
He is the,
He was the assistant branch.
can you give,
Your lordship, I'll provide.
huh, can you give me that? Yes. Yes.
The third officer, your lordship, Ashapurna Singh, who was the senior most, he was the chief manager of the branch. Against him, 10 allegations were brought in, out of which 6 allegations stands proved, your lordship. As there, from these allegations and the allegations proved, we can make out that 3 officers are on different footing. Now, your lordship, the role of the petitioner was of the highest order, your lordship, because of the fact that he was the field officer.
He is supposed to verify,
Yes, your lordship.
scrutinize at the field level,
The field
right?
level, he had to go to the place for survey wherever the KCC loans were given, your lordship, and he has to give a survey report, and
And
according
based on that report, the other
to the
officers will,
X, your lordship.
now, of course, their corresponding duty would be to not blindly see it,
Lordship,
but that is where they got
the punishments of
the
reduction of
punishments.
lower.
This is what you are trying to say, na,
Yes,
Mr.
your lordship. Yes, your
Buragohain?
lordship. This is my point, your lordship. So the allegations and the footing on which the 3 officers stands is a different footing. Now regarding the appreciation of the evidence, your lordship, as your lordship has likely pointed out, at this stage, your lordship, the read court reappreciating the evidence
Will
your
not
lordship,
arise.
Not arise, your lordship. And the findings which are the findings which has come out, your lordship, by the inquiry committee and which was affirmed by the inquiry authority and the appellate authority, your lordship, as in my humble submission, your lordship, this is
Sufficient,
sufficient, your lordship.
proportionate to the grave man.
Lordship, because all the process of natural justice and every opportunity was accorded to the petitioner to prove his case, your lordship.
Okay. That parity part, anywhere you have written in the brief, any of your affidavits, anything?
Your lordship, in my affidavit in opposition, paragraph number 32.
Paragraph number 32.
22.
This is by one Madan LS. Page number?
22, your lordship. If I may read, your lordship.
One sec, let me first
Lordship,
just,
lordship.
page 22, yes,
Page
para 33.
32, your lordship.
32, yes.
That with reference to averments made in paragraph number 40, is admitted that disciplinary proceeding was conducted against the 2 officials named in the said paragraph, and that comparatively lesser punishment order was against them. But I say that charges against said 2 officials were not similar on all fours at all with the charges leveled against the petitioner, and consequently those officials were left off with lesser amount of penalty, and there is nothing for the petitioner to hold any grudge against them, your lordship, with regard to that.
Okay.
And also, your lordship, by that time, your lordship, this inquiry has been concluded against the petitioner, as I have already, your lordship, submitted. He has already been retired from service. So any other punishment could not have been imposed.
Could have, we could have deducted it.
Even a compulsory term.
Lordship, because he is already retired, your lordship, and his allegations are also much more grave.
That is different. I'm not disagreeing with that part of your submission, because that is where now this court will have to see,
Lordship.
keeping in mind the principles laid down by the apex court as regards the proportionality of punishment, right? So that is why I was also asking about if there is any chart, because generally in such cases, if the charter of duties are brought in by way of evidence or brought out during cross-examination, it helps to understand, you see, whether, of course, by going by the nature, when you are saying you are probably right, that he being the field officer, his responsibility at the field was to do all the inquiry, verifications. Now that was the main thing, which he failed, because of which these loans ultimately got sanctioned, right? This is what you're trying to say. The others, of course, they are also guilty, but proportionate to their whatever you thought is deserving is been given. Now, same just because they have been given a lesser punishment doesn't mean the same will be given to this person against whom out of 16 charges, 12 has been proved. Anything more? This is what is your submissions. All right. Yes, sir. You are Mr.
RJ Das.
Das, na?
RJ Das.
RJ Das. You know, I know you all by face, but sometimes
Lordship.
I get confused with the surnames. Yes, Mr. Das.
Lordship, regarding the I being arrested, I was arrested on April.
You are acquitted.
I'm not acquitted.
Not acquitted.
I'm being discharged. Much higher than acquitted would be after evidences have been there, whether honorably acquitted, not
But
honorably.
that's not a ground you have taken.
No, I have.
You
because
didn't.
I was given. I was
You
discharged.
did not take that ground that because you have been discharged in the criminal proceeding, the allegations whether similar, and that
No,
is not.
that is not even the
Correct.
part.
So let's not get into that.
Because he had said it, I just said it.
You have said discharge. Okay.
Because there is a kind
Okay,
of. So he has
okay.
been discharged.
Okay.
And this is a part of the record also.
Okay.
Lordship, what I want to submit.
That part of the record, where do I find page?
Page in my affidavit in reply, page 22, annexure P30.
Page 22.
Yes, 22 to 20.
P30.
And in my affidavit in reply.
P30 is, I think, at page 8. Okay, I got it. 592. Right.
Running would be nowadays. I do not.
No, I have it. It is 586.
It's an order dated 28/9.
Yes, I have it. Mr. Das, I have got it.
Absolutely no evidence was there, and that's why I was.
Discharges made on the ground that is an allegation and so are not connected with the instant case, and rather the same is already under investigation in Hazo. But it says in investigation in Hazo PS 812.
That when did that nothing has happened in that case. This is
Anyway, it's not necessary to go into this because
there were 2 cases, there were other things, good cases.
Yes, all right.
Anyway, that is not the part, it's not similar.
okay, Mr. Das.
And secondly, now, Lordship, my punishment was given at an earlier stage. Both the officers proceeding concluded later on.
Later on.
Now, Lordship is aware that any document cannot be enhanced by way of an affidavit. Now, they knew that Sunil Mishra was given a punishment of dismissal, dismissal, sorry. In the inquiry report of the other 2, there is not a single whisper as to why what they are saying right now, if it is to be taken to be true, as to why these 2 persons were given a lesser punishment.
Is it necessary?
Lordship, if it is necessary, if when
Is
it's
it
the
a-
same transaction.
No, but transaction same. Is the charge sheet same?
Same.
Charge sheet.
Yes,
The allegations are given separately individually.
Charges are the same. It's regarding
Correct,
fine.
but the allegations are separately given.
But the allegation, the
The
main
charge sheet, if let me just be sure, the charge sheet is page which you had shown. From here, from your paper book, at what page do I find the charge sheet?
paper book. Lordship, in this is Asapuna's thing is page 60.
No, Mr. Counsel, yours.
My charge sheet.
Yes, I am only concerned about you.
351.
351.
351. Oh, charge sheet. Sorry.
So that's inquiry.
Anyways, charge sheet is page.
I think it's P6 and P7.
39.
Page
39 of my paper book.
No, I mean, of the brief. Huh? 82. Ah, yes, P6. Thank you, Mr. Buragohai. Now, this is addressed to the petitioner. And this is dated 11 to 19.
11 to 19.
So this is the first show cause notice, or this is the charge sheet?
This is charge sheet.
Charge sheet. Before this, anything else given? No.
Yes, yes.
Now this charge sheet is 11 to 19. What is the date of the other two gentlemen's charge sheets? Just give me the dates.
11/9/2019.
11/9.
2019 of Asa Purna Singh.
Asa Purna. And the other one?
And Bhaskar Datta's is
11/3/2019.
11/3.
2019.
no 11/9.
Asha Purna is 11/9. Bhaskar.
Bhaskar also 11/9.
Please verify.
Okay.
Bhaskar
Datta.
Datta. Just give me the date of the charge sheet.
Yes.
11/3, Your Lordship.
11/3. 2019.
Lordship, I'm sorry. Both are 11/3. I'm sorry. Both are 11/3.
Mr. Buragoy, Asha Purna, 11/9 or 11/3?
11/3. It's render.
11/3, Lordship.
Both are 11/3.
And you are 11/2.
11/2/2009.
Okay. Now, where do I find your show cause notice? First show cause notice. I think this is at page 48.
Lordship.
Correct?
48.
Page 48. Okay, fine. First show cause notice, isn't it?
Yeah.
28/12/18. Okay.
When I was in judicial custody.
All right. Now, please sum up your reply. What judgments you want to show? On proportionality, you must be carrying something on
Yes,
proportion.
Lordship, my first would be State of UP versus Rajpal Singh, 2010, 5 SCC 783.
Yes. This is paragraph.
This is paragraph.
Yes. Just short paragraph,
Yes,
I think. It's
paragraph.
one page.
5.
Undoubtedly, I think. 5, yes.
5.
Read, though on
Though on
principle.
principle, the ratio in aforesaid cases would ordinarily apply, but in the case of
Mr. Counsel, why don't you read from
1
from 4?
4. It is contended on the behalf of the appellants that once the charges has to be established, it was not appropriate. No, Lodge. I'm sorry. This is Rajpal Singh. Okay, this is proportional. I'm sorry. I'm absolutely sorry, Lodge.
No problem, no problem. I think this you thought you wanted it probably for the criminal thing. For same charges. It is undoubtedly open for the disciplinary authority to deal with the delinquency and once charges are established to award appropriate punishment. But when the charges are same and identical in relation to one and the same incident, then to deal with the delinquents differently in the award of punishment would be discriminatory. This is what I think you want to show. In this view of the matter, we see no infirmity with the impugned order requiring our interference under so and so. So this is for parity of punishment. Now, where do I get the charge sheets? The two charge sheets of the other two persons are there in your compilation.
In compilation,
in that compilation.
Is also a part of the record also.
In this paper book.
Not in this paper book because I had not received it. I had given a specific statement.
This paper book is your. This is actually that writ petition which you have.
Yes, in the writ petition in
You
paragraph.
You
in
don't
paragraph-
have a copy of this writ petition.
No, I have the charge sheet of the other two officers.
You don't have it.
No, that was given by them in the form of an affidavit.
Anyway, you can just give me those allegations you were referring to.
That lordship, if the lordship takes the paperwork, I have given the specific thing. The charge sheet file, where it is found.
You can't put good. Oh. Yet a come across.
No, not that one.
Mr. Das,
Yes.
for the convenience of the court, just flag mark the 3 charge sheets where that allegations figures out, right? And just write the names in the flag. That's all.
I'll do that. That I'll do in this paperwork.
Yes. You can just give, or while you are submitting, Mr. Buragohai, please help him. Just do that. It did your comment, Mr. Buragohai did your. The 3 charge sheets and just write on top on the flag, okay? The names. Yes, Mr. Das.
Yes. In the second judgment, which is Naresh Chandra Bharadwaj, 2019, 15 SCC 786.
Yes. Naresh.
Naresh Chandra Bharadwaj.
Yes.
Paragraph 6.
This is for
Again parity.
parity. So I think the concept of parity would be when identical and same incident.
Yes.
That is,
That
isn't it?
So the charges here is identical and is about the same incidents. So in paragraph 6.
Incident undoubtedly same.
Yes.
Now, as regards the charges being identical, that is why that reference to those 3 charge sheets would be required.
Yes.
For the
verbatim is same.
for the
What they
court
have-
to see whether they are equal, and if so, why should there be a discrimination?
Yes.
Right.
Yes.
I think that would be the short
That is
question
the short question. and
which
it-
calls for
Yes.
adjudication.
Yes. What they had, they sought to do is that there is allegation 9, allegation.
Correct.
10,
Now,
that is
but you see, the sum and substance of these 9 allegations or
Is
6
this-
allegations or 12 allegations
Yes.
is what?
What is the loss?
Correct.
Is the loss. That's the
If not just the loss, Mr. Das, not just the loss, because how one has to do will also come. Suppose you being the field of being the field officer, your responsibility was much more. So those allegations will spell it out, and which has been proved. You understand? So the some application of mind has to be made.
Yes.
Definitely, I don't agree 9, 6, and 12. That is certainly not the formula. That would be very mathematical.
Yes.
But one has to understand the overall charges. If they seems to be identical, then there is no question as to have a as to awarding different punishments to one another.
That's my submission and
Yes.
it's on record. And
Yes. So I think that is the
that is it
that
has
is.
to be identical.
Mr. Buragohai, you have understood what I am trying to say. So you help me to find out that answer by marking the relevant pages. Once you do it, show it to Mr. Das and then pass it on to the court. Yes.
Paragraph 6. May I read just for the
Yes, please. Yes, please.
There is really no difference in the proposition which is sought to be propounded, except in that in the later judgment, the principles have been succinctly summarized in the last paragraph of the judgment, which read as under. The judgment is written. The principles discussed above can be summed up and summarized as follows. When charges of misconduct is proved in an inquiry, the quantum of punishment to be imposed in a particular case is essentially the domain of the departmental authorities. The court cannot assume the function of disciplinary departmental authorities and to decide the quantum of punishment and nature of penalty to be awarded, as this function is exclusively within the jurisdiction of the competent authority. Limited judicial review is available to interfere with the punishment imposed by the disciplinary authority only in cases where such penalty is found to be shocking to the conscience of the court. Even in such a case where punishment is set aside as shockingly disproportionate to the nature of charges framed against the delinquent employee, the appropriate course of action is to remit the matter back to the disciplinary authority or appellate authority with direction to pass appropriate order of penalty. The court by itself cannot mandate as to what should be the penalty in such a case. The only exception to the principle stated in 1904 above would be in those cases where the co-delinquent is awarded lesser punishment by the disciplinary authority even when the charges of misconduct was identical or the court delinquent was foisted with more serious charges. This would be on the doctrine of equality, when it is found that the employee concerned and the co-delinquent are equally placed. However, there has to be a complete parity between the two, not only in the respect of nature of charges, but subsequent conduct as well as after service of charge sheet in the two cases. If the co-delinquent accept the charges, indicating remorse with unqualified apology, lesser punishment to him would be justifiable. That's a different part on the thing, but the sum and substance is.
And can you say them they are co-delinquents because they are not part of the same charge sheet?
No.
There are three different charge sheets.
Now, Lordship, if they
Generally, when we say co-accused, co-delinquent, it is when there is a common charge sheet.
now they don't.
I'm asking you.
No, Lordship.
I'm just asking you.
The Lordship, they co-delinquent, in my respectful thing to the understanding would be, since this is part of the same transaction.
Similar understood.
Yeah.
There is no difficulty.
Now, if they do not.
I'm only asking
Yeah.
you because co means when you are part of the same charge sheet,
To my
FIR,
no,
isn't it?
co-accused and co-delinquent cannot be interchangeably used in my respectful submission, because the question again here is that it's their disciplinary authority thing. They can proceed together, they can proceed separately.
No, now proceeding separately together is also different. Now, when they are issuing the charge sheets, they have issued three separate charge sheets to these three delinquent officers, and the allegations may be somewhat similar, but they're not verbatimly identical to each other, because in respect of one there is about 12, in respect of one there is 9, in respect of another one there is 6.
9, 10, 16.
9, 10, 16.
9, 10, 16.
So there are different, correct? So you cannot say that absolutely same. Sum and substance, that is different. That one has to read and find out. But are you trying, what I am trying to...
I have understood.
Huh.
Lordship, if I have understood correctly, what Lordship has fallen from Lordship is that whether co-delinquent, the term co-delinquent.
Because if it was a co-delinquent and same charges, there was absolutely no difficult for this court to, set aside the penalty part and say, no, this is absolutely discrimination and you have to have a parity. There was no difficulty. But here,
Lordship has
a little bit of...
Yes, Lordship, what has happened right now? Lordship, regarding, again, I'm submit, Lordship had what had fallen from Lordship earlier is that the numbers 9, 16, 10, these things are done by them, but it's sum and substance. Now you have done certain this thing. Now we have to go by the record. They are saying there is a pecuniary loss. And how does pecuniary loss happen? These are the way the pecuniary loss happened.
No, not only these are the way, it is because what role as per your post you had to play.
Yes.
It has to be qua that. It cannot be, one cannot ignore.
Now,
it is not just the loss.
Now
Overall, because of all these three people, because if suppose the controlling officer would have been more vigilant and he would have seen something, then maybe nothing could have happened.
Yes.
So he is also at fault.
Yes.
Sanctioning similarly. Before sanctioning, if he would have done his duty in terms of the book, perhaps this loss would not have come. Therefore, he is also equally responsible.
Yes.
Now, but that doesn't mean that just because they were given lesser punishment, the field officer will also automatically get the same punishment. This is one way of another perception,
but
right?
whether I should be given the highest punishment. That is where okay.
No, that is where one has to see as a field officer what were the allegations, what allegations were proved against you. That will speak of your duty as a field officer, because by and large it appears that perhaps your duty was much more than the sanctioning and controlling, because they are only sanctioning and the controlling officers. Whereas all these inquiry, verification at the field, by just the nature of the term field officer, as one would understand, were required to be done by the field officer. Had the field officer done his part properly, then perhaps nothing would have gone wrong. There was no occasion for the sanctioning officer and controlling officer also to have gone wrong. Correct? That could be also one way. I'm only, don't get intimidated.
No.
I'm trying to get out the best answer from you.
The counter to that would be, then the top official sanctioning and the author, they are just a post office.
No, they are not.
They
That
are
is
not.
why they have to check.
they-
You see, that is why punishments have been given.
Yes, and punishment.
Right.
Now that's where
It's not that they have been exonerated.
no, it's not that they have been exonerated, but what is if their inquiry report is looked into it, if Lordship allows me to just read one line.
Yes, yes, please read.
Just reading
Yes,
one-
yes, read.
I'm not reading the whole inquiry report.
Just read.
What does regarding that loss,
Hmm.
what does the presenting officer says? I'm talking about the bank's perspective.
Yes, please read.
The CSO Bhaskar Datta could not realize the role and responsibility associated with the post he hold. So this is a thing which their bank is saying he could not realize. He could not realize this thing.
The
He
responsibility he has.
He failed to put utmost devotion and due diligence in the day-to-day work at branch. Had he been a bit alert, he could have stopped. He could have stopped such fraudulent activities leading to the pecuniary loss.
You see,
to the bank.
Mr. Das, that is why he has been given the penalty of reduction of rank.
That now, had it been now,
We cannot enhance that. We cannot enhance that.
yes, Lordship.
That
they
is
are
not
there.
before this court.
This is not before
If
this.
that was before this court, maybe I would have enhanced it.
That is a different. But point now they have come. Whether I should be given that punishment, because I've been given the topmost, even a removals of service or a compulsory retirement.
Now, in order, the principle for this court to apply is to see whether it shocks the conscience of the
Yes,
court.
yes. With the
Meaning otherwise, that the punishment is so shocking to the gravamen of the charge that has been proved.
Lordship.
Right.
Lordship. So, and
That part, this court is having a bit reservation because
Lordship, if Lordship,
except the pay parity, which has to be examined. Of course, I'm going to examine that. And if I find ki no, sum and substance were same, therefore it could not have, then I will lessen it. No difficult. If I don't, for a moment, if I keep that aside, then it's not shocking. Then it is not shocking. You understanding, Mr. Das, what I'm trying to say?
yes, Lordship. For that.
Because this is the way the bank could assure that in future these things don't happen. They have to take the extreme measures, right?
Then Lordship, allow me to place the document that they have.
There was one more judgment you wanted to
yes,
say. What is that? Tata Engineering?
Tata Engineering.
What is that for?
Tata Engineering on the same principle.
Proportionate, pay parity or proportionate?
Parity.
Parity. Yes. What is the document you want to rely?
Now, Lordship, in a banking sector, loss has to be by a direct action where there is a loss. Now, this loss that they are saying is a projected loss. It is not even a loss that had happened. It says that it might happen, then this is the loss because this is the projected loss that they are talking about. And I have stated in my repetition as well.
Okay, noted.
That now, second Lordship, here again regarding the charge, if Lordship allows, again the charge sheet, if we read again, just to impress
Yes.
Lordship, because ultimately my case
Yes.
hinges on the parity of the
You
charge
have
sheet.
marked it,
I
Mr.
have
Burago?
also-
Yes. Which one do you want me to take first?
First is Ashapurna, page 2.
Ashapurna. Let us see Ashapurna. From the very first moment, you've been wanting me to go through the charge sheet of Ashapurna. All right. For your satisfaction, let us now see Ashapurna.
During your tenure as chief manager at Dodora branch from 1909-2007,
Where are you reading from?
articles of charge.
Okay, this is, I think, Ashapurna, the charge sheet. Okay, yes. Read.
During your tenure as chief manager at Dodora branch from 1909-2017 to till date, certain serious irregularities were alleged to have been committed by you, and due to your such irregular activities, the bank is exposed to suffer a pecuniary loss to the tune of 205.31 lakhs besides reputational loss. Two aspects. one pecuniary, second reputational loss. This is the thing, how they are talking, it says due to your irregular activities. Now, there are irregular activities, because of their irregular activities, these two things happen. You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions. These acts are unbecoming of an officer. So, if we just summarize this thing, two parts, two things are there. There's a loss of 205 and there's a reputational loss. Two parts have. Why? Because of the irregular activities of Asapurna Singh. Now this
Reputation or reputation loss?
one is
Loss
pecuniary
of 205 and reputation.
and reputation. Two aspects. How would this happen? Due to your irregular activities.
Yes.
So certain serious irregularities and these irregular activities, because of these two irregular activities, these two things happen.
Yes.
This is the sum and substance. So what are the irregular activities? These are the 10 allegations they have said. So these 10 allegations, because of these 10 allegations, what is the consequential part? Is the 205 and the reputation loss. This is the charge. This is the charge. There is no dispute to the fact. Now comes Bhaskar Datta,
Yes.
which is page 17.
Yes. Yes.
Again, I read. During your tenure as assistant branch manager at Dadara branch from 16/10/2017 to till date, certain serious irregularities were alleged to have committed by you, and due to your such irregular activities, the bank is exposed to such a pecuniary loss to the tune of 205.31 lakhs besides reputation loss. You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instruction. Absolutely verbatim same.
Yes. Yes.
Lordship, this is absolutely verbatim same.
Yes.
Page 40.
Yes.
During your tenure as field officer at Dadara branch from October 2017 to August 2018, certain serious irregularities were alleged to have committed by you, and due to your such irregular activities, the bank is exposed to serve a pecuniary loss to the tune of 205 lakhs besides reputational loss. You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions.
Yes. Same.
Verbatim same.
Okay.
205 reputational loss. Why? Certainly. The
So
irregular.
the primary allegation remains same.
Absolutely.
Where only thing when in the statement of imputation of the
Yes.
specific lapses on their part,
Yes.
and regards to their role, considering perhaps the charges have been made.
So
Perhaps,
but
right?
That's a difference. So
Hmm.
they got a
But the primary thing is the same.
state. So they-
Pecuniary and reputation
Yes.
loss because of the irregularities.
irregularities. Now he did 10 irregularities, one did 9, I did 16. I'm not saying give me the same for that, but should I be given the topmost, the highest, the harshest? I'm not getting pension, I'm not getting my PF, I'm not getting my GPF. I'm sorry, I got the provident fund, which is my contribution, but the other contribution is not there. Gratuity I have not got. So should I be given the highest punishment? This is where.
Where is that SBI regulation? That rule 53, na? And Mr. Burago, anything about that dismissed? If a person is dismissed, then is retired. Anything to that? Do you have something?
This 19.3, there is a 19.3, once he is retired, if there is a departmental proceeding which starts before it, the departmental proceeding proceeds.
There is there.
That is there.
You please mark it also. I probably have.
Page 128 is the
I don't
19.3.
think we will have a book. Asanigetu.
No, Lordship, I have annexed the 19.3 in the.
If you can just flag mark and pass it over for the time being.
No, Lordship, it's in the paper
Huh?
book only.
Paper book.
Page 128.
128. 19.3.
It's 19.3, under which the.
No, 128 says file so and so. We
Oh,
have
sorry. It's the exact rules. I have.
You just, you read it and then pass it over, but whatever you want to rely, just mark it, please. One of you can
Lordship,
just
regarding
give.
the rules to, I'm not relying on per se, it's just because of
No,
50
that particular 19 that you have just said, I just wanted to have a look, and that 53 which has been referred in that allegations, no?
Huh.
The charge sheet,
53
53,
is
no, rule 54.
54.
I want to see rule 54 once.
It says, it's 54 says, every officer shall at all times take all possible steps to ensure and protect the interests of the bank and discharge his duties with utmost integrity, honesty, devotion, and diligence, and do nothing which is unbecoming of an officer.
Is there a list of major, minor punishments? Or what are the punishments? Is it given? There has to be a list.
Yes.
Right, Mr. Buragohar? Just, I wanted those part.
The penalties.
Yes, yes.
Penalties.
See, I'm proposing to start the dictation at 2 o'clock.
Okay, Lordship.
So that is why I'm asking for all this.
Lordship, we'll get it then. We will get
That,
to
that part you,
all the
Huh.
relevant things. That
relevant, whatever is from the rule.
19.3, 50 thing.
And the list of penalties.
List.
And Mr. Buragmaha, you just mentioned about the dismissal, because one of your argument is that because this person has been dismissed now, retired, now how to that I don't think will hold, because that is unfair. But I want to see how you have categorized the
list of penalties.
list of penalties. That is one thing I want to see.
We'll get it. We'll get it.
Anything more?
The charges I have shown is the sum and substance, and this is my basic thing about the profession. That I'll conclude then. 2 o'clock, then we can. Almost 1.
Then I think
Yes.
makes no sense
Say-
of starting
Now.
for 2 minutes. At 2, you have that ready, huh?
I'll have.
Will at least let me make an attempt and see how it goes.
Deeply obliged. Lordship, regarding the delinquent part, Lordship had asked about. Okay. Now, Lordship, in this instant case, Lordship have showed the charge sheet being the same. It is they who did not proceed in the same thing, the charges being the same. So that to fulfill the definition of delinquent, co-delinquent, that in my respectful submission, it fulfills in this instant case. Though ideally it should be co-delinquent means the part of the same charge sheet. That there is no disputed fact. But in this instant case, as I have shown, Lordship, the charges being the same, they actually, both the officers fall and will be within the ambit of co-delinquent. That's my.
All right.
That's
Regarding the parity part,
And that rules?
rules I've got it, Your Lordship.
Yes.
Your Lordship, may kindly take up 2018 14 SCR 427, State of Tamil Nadu versus M. Mangaya Krishnadas.
Yes. Paragraph.
Paragraph number 13, page 431, Your Lordship. If I may read, Your Lordship.
Yes.
There are several reasons, in our view, why the approach of the High Court in the present case cannot be accepted. Paragraph number 14.
Yes.
First, in seeking to apply the principle of parity of treatment, the High Court has manifestly failed to notice that the gravity of misconduct which was established against the appellants was distinct from and of a more serious nature than what was found against the other employees. This expressly emerges from a perusal of the chart which has been extracted above. The nature and extent of a dereliction of duty and the consequences of the dereliction are significant matters which can legitimately be borne in mind by the disciplinary authority. Well, see paragraph number 15.
Yes.
Second, while noticing that such a submission was in fact made before the learned single judge, the division bench proceeded to apply the yardstick of parity. Parity could not be applied for the simple reason that there is a material distinction in the case of the misconduct alleged against the appellants as compared to the other employees. While the language of the charge may be similar, in other cases, that does not detract from the fact that amount that the amount involved and the extent of lack of verification in the case of the respondents is of much higher order. The division bench, having noticed that in a matter of this nature, the principle of parity cannot be attracted, nonetheless affirmed.
Mr. Buragohai,
Lordship.
looks like you missed your lunch today. Yes.
Paragraph number 16. Third, the approach of both learned single judge and the division bench cannot be accepted, having due regard to the
All right,
parameters.
understood.
Your Lordship, the other judgments, Your Lordship, regarding
This is actually squarely to the point which the query that this court
court
was
has-
posing.
Lordship.
That on that this is
Lordship.
so the basic is that comparison.
Comparison.
Ultimately, how after reading what comes out.
Lordship.
That is the question.
The
Yes.
Other judgment, Your Lordship, 2014-13 SCR 1312, Union of India versus P. Gunasekaran,
Paragraph
page number 1320, Your Lordship, paragraph number 13.
13. Pages
1320, Your Lordship.
yes.
If I may read, Your Lordship.
Yes, please.
Despite the well-settled position, it is painfully disturbing to note that the High Court has acted as an appellate authority in the disciplinary proceedings, reappreciating even the evidence before the inquiry officer. The finding on charge number 1 was accepted by the disciplinary authority and was also endorsed by the Central Administrative Tribunal. In disciplinary proceedings, the High Court is not and cannot act as a second court of first appeal. The High Court, in exercise of its powers under Article 226, 227 of the Constitution of India, shall not venture into reappreciation of evidence. The High Court can only see whether here, Your Lordship, the points are given.
Yes. High Court can only see.
Into number A, the inquiry is held by a competent authority. Number B, the inquiry is held according to the procedure prescribed in that behalf. Point number C, there is violation of the principles of natural justice in conducting the proceedings. D, the authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and merits of the case. E, the authorities have allowed themselves to be influenced by irrelevant or extraneous considerations. F, the conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could ever have arrived at such conclusion. G, the disciplinary authority had erroneously failed to admit the admissible and
All right.
material evidence. And Your Lordship, the number F, Your Lordship.
Yes, I have seen.
That is the
Conclusion.
conclusion. The under
Okay,
226
this is settled law. No problem. Yes. And also last the under Article 226, 227, the High Court shall not
reappreciate the evidence, interfere with
go into the proportionality of punishment
Lordship.
unless it
It
shocks
shocks the
the conscience. These are all otherwise settled position. It is just how it all fits in the context of each case.
Okay.
There cannot be any, you see, the case laws relied by Mr. Das and by you. At the end of the day, it's the same principle. Correct.
Fit
It is
the
just
case.
how you fit into it. Except in one of in that Tamil Nadu, there you have brought out something more
Lordship.
when that parity issue
parity
comes. Okay, very well. Yes, please take down.
No.
Heard Mr. H.
Ardas.
RJ, na? RJ Das, Learned Counsel, appearing for the writ petitioner. Also heard Mr. H. Buragohai, Learned, you are appearing as a standing counsel.
We are penal advocates.
Learned Government Counsel.
No, penal advocates from State Bank of India.
Learned, not standing.
Not State.
Learned Counsel for the SBI respondents. Stop. By way of this petition under Article 226 of the Constitution of India, the writ petitioner is assailing inter alia the order of major penalty dated 29/11/2019 and the appellate order dated 1/6/2020. Stop. The brief facts of the case is that, counsels, you may take your seats. And during I'm dictating the submission parts, anything if I forget which needs to be added, you are free to point it out. Okay. Otherwise, you can take a note of it so that at the end of the dictation, if there is any error or corrections.
The flow will not be.
Yes. Okay. The brief facts of the case is that the petitioner, while was serving as deputy manager within bracket MMGS Roman 2 regional business office at the regional business office Guwahati within bracket rural in the State Bank of India, after being placed under suspension and after holding disciplinary proceeding was imposed with the penalty of dismissal from service by final order dated 29/11/2019 passed by the general manager within bracket NW- Roman 1 and appointing authority affirming the penalty of dismissal from service with forfeiture of gratuity and treating the period of suspension as not on duty. Stop. Mr. So-and-so, no, that did, yeah, that aggrieved by the impugned order of penalty and the appellate authorities order of upholding the penalty of dismissal, the present writ petition has been filed. Mr. Das, so-and-so, submits that two other employees of the respondent bank was also charge sheeted along with the petitioner for the same offense, for the same incident, wherein for the same incident, however, lesser punishment was awarded to the other two delinquents. He further submits that the allegations leveled against the three delinquents, including the petitioner, were identical and similar. However, stringent and maximum punishment of dismissal from service was awarded in respect of the petitioner, while lesser punishments were awarded against the other two delinquent employees. He accordingly submits that the respondents have treated the case of the petitioner in a discriminatory manner for which the impugned order of penalty requires to be interfered with. In support of the aforesaid submissions, he relies upon the following decisions of the apex court. 1, 2, 3 করে দিবা, huh? So-and-so versus so-and-so, 2001, volume 10 SSE 530. So-and-so versus so-and-so, 2019, volume 15 SSE 786. So-and-so versus so-and-so, 2010, volume 5 SSE 783. That's it, isn't it? That is your main.
Mean.
I have
right.
covered it in those three submissions of yours, I think.
Only thing is that if I fail here, then the perversity part I would
He
like.
further submits that he further submits that the findings of the disciplinary proceedings are also perverse inasmuch as
It was based on, there were no evidence.
inasmuch as in respect of few of the allegations
Yes,
there were no
evidence
evidence
and relevant evidence was not.
and relevant evidences were not taken into account by the disciplinary authority. Stop. Per contra, Mr. Buragohai, learned so and so submits that though the allegation relates to the same incident, however, there is a material distinction in the case of the alleged irregularities against the petitioner as compared to the other two employees. Stop. He further submits that the allegation in respect of the petitioner being more serious than that of the other two employees, the punishment awarded by the disciplinary authorities warrants and is proportionate to the gravamen of the charge and therefore warrants no interference from this court under Article 226 of the Constitution of India. In support of the aforesaid submissions, he relies upon the following two cases of the Apex Court. One, State of Tamil Nadu versus so-and-so, 2018, volume 14, SCR 427. And number two, so-and-so versus so-and-so, 2014, 13 SCR 1312. Right, Mr. Buragohai? I have given my anxious considerations to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also duly considered the case laws cited at the bar. Apt at the outset, to lay down the relevant facts, lay down the relevant admitted facts. Stop. It appears that the petitioner was placed under suspension by order dated 16/10/2018 whereafter a show cause notice dated 28/12/2018 was issued to the petitioner to show cause as why disciplinary proceedings shall not be initiated against the petitioner in connection with serious irregularities relating to KCC loan accounts, show cause notice dated 28/12/2018 reads as hereunder. The allegation. Remember A to A, huh? A to A. Pursuant to the reply submitted by the petitioner on 17/1/2019, explaining the 15 allegations contained in the show cause notice, the respondent authority, upon due consideration of the same, was pleased to issue charge sheet against the petitioner on 11/2/2019, wherein the articles of charges frame against the petitioner for his alleged lapses reads as for his alleged lapses while he was posted as field officer at Dadra branch of the State Bank so and so during the period from October 2017 to August 2018 reads as under page 84. To 86. Reading of the aforesaid 16 allegations as contained in the statement of imputation of lapses alleged against the petitioner, it appears that the petitioner has been alleged committing irregularity while performing his duties as field officer, for which the bank has allegedly suffered a pecuniary loss to the tune of rupees 205.31 lakhs besides reputational loss. Upon constituting of the inquiry officer was different from the disciplinary authority. Different. Upon constituting of an inquiry officer, the inquiry was held against the petitioner, wherein admittedly all requisite opportunities as required were afforded to the petitioner. The inquiry officer, after completing the inquiry proceedings, submitted its inquiry report on 27/3/19. On 27/3/19. Is it correct? Just check the date. Stop. Thereafter, the disciplinary authority forwarded the inquiry report cum finding. No, it's that date is sorry, 3919.
It's 3990.
3990.
That's what.
Okay. Thereafter, the disciplinary authorities by letter dated 26/9/2019 furnished a copy of the aforesaid inquiry report cum findings to the writ petitioner, calling for his
Comments. Page 350.
page
349 is the letter of the inquiry.
that I got. Where is that last part?
350.
Calling for his
Comments.
comments against the aforesaid inquiry report. The writ petitioner thereafter furnished his response by letter dated
26/9/2019.
26
411.
9
2019.
2019. Stop. That one second. I think one date I may have by mistakenly said that second show cause notice calling for your comments. What is that date?
18/9/2019.
18/9
2019.
2019. Okay. Thereafter, the disciplinary authorities, upon perusing the reply of the petitioner by letter dated 13/11/2019, called upon the petitioner to appear before the respondent authorities on 19/11/2019 for personal hearing and or make submission as to why the penalty of dismissal and forfeiture of his gratuity shall not be imposed on him. Thereafter, impune penalty
Page 433.
$430.
Fine. And penalty order is 9/12/2019. The forwarding letter 432.
No,
Sorry.
what is this order in passed the order dated 29/11/19 at 4:33? What is that?
No, 432 preceding. That's the covering letter is 432.
For what?
This is the penalty order.
This is it's quite detailed. This is the final order. Then you say thereafter, the disciplinary authorities by passed the final order on 29/11/2019 which was forwarded to the petitioner by letter dated 9/12/2019. Relevant portion of the final order dated so and so reads as hereunder. I think 4, na? Point 4. Correct? No, point 4 is the proposal. Where is that punishment given?
Punishment is page 449.
Paragraph 7.
Paragraph 7.
449. Relevant Nokoba. A perusal of the aforesaid final order indicates, comma, it is apparent that the following punishment was awarded by the disciplinary authority against the petitioner. Quote unquote, paragraph 6 of page 449, paragraph 7 of page 449. Against this, an appeal was filed, which was rejected by the appellate authority by order dated 1/6/2020.
Page 500 relevant.
Yes. It appears that along with the petitioner, two other employees, i.e., the names,
Ashapurna Singh,
Ashapurna Singh within bracket,
the controlling authority,
and
Bhaskar Datta,
Bhaskar Datta within bracket,
the sanctioning authority, Dadara branch,
was also similarly charged, for the same incident, and the disciplinary authorities by orders dated, please give me the two orders dated so and so and so and
29/7/2020
and
37/2020 of Ashapurna Singh and both 37/2020.
by orders dated so and so imposed the following penalty respectively upon the said two employees. 1 and 2. Yes.
Reduction to a low.
Where do I find it? That page, just give me the page.
Page is 9 to. It will be page 96 to 105 of the affidavit filed on behalf of the respondent in IA.
Just give me the page number.
96 to 105.
Just that operating part wherever I get the punishment.
In the IA part.
IA.
1050/2021.
Yes, where do I find it? I just need that penalty. Reduction to a lower stage in the time scale of pay by one stage. That part.
Yes.
I think it is only one then. No, there are only
One.
only one. Impose the penalty of reduction to a lower stage in the time scale of pay by one stage for 1 year, with further direction that the officer will not earn increment to pay during the period of such reduction, and on expiry of such period, the reduction will have the effect of postponing the future increments of his pay in terms of rule number 67
67F.
F of SBIO SR 1992 to both the petition to both the aforesaid two delinquent employees respectively to it will page number to 105 I. Yes, where are the rules?
What's a small factual part?
Yes, please.
Here, Ashapurna did not prefer an appeal, but Bhaskar Datta preferred an appeal, and it was that's a factual part.
No problem. That I'm not getting in. Yes, which page?
The pink flag mark, Your Lordship. It is the rule 19.
19.3.
19.3.
Pertinent that he retired when? During the pendency of the disciplinary proceeding.
Yes.
Pertinent that the petitioner, during the pendency of the disciplinary proceedings, retired from service on such and such date.
29 to 2000,
28 to.
28 to 2019.
Pala? Rule 19.3 of the SBI Officers Service Rules 1992, hereinafter referred to as the existing service rules, reads as under. Quote unquote, 19.3. It appears that after the retirement of the petitioner, as per rule so and so, the disciplinary proceedings which was initiated against the petitioner continued, and ultimately, by the impugned order referred above, the penalty of dismissal from service has been imposed against the petitioner. Yes, which is that other rule, 50 something?
54.
67.
No, 67 or 54. 50 subsection
Yes.
4.
Misconduct is 66, right? Anything about irregularity? No. I think it will come under misconduct.
Your Lordship, the penalty part, Your Lordship, it's section 2. It is in rule 67.
That I have got.
Ah.
But otherwise, the petitioners and the others have been alleged of misconduct, isn't it?
Lordship.
So Rule 66 provides what is misconduct, which reads as under, quote unquote. Isn't it? This is me also relevant, I think. Or this is not required.
No.
This is not required. No, like 66. No. No.
Lordship, 54 would be
50?
50 subsection 4.
Okay. Okay.
Page 60, I think, internal page.
Yes, because this is what I think they had mentioned.
Yes.
That is why I was asking for this.
The charge sheet mentioned 50
Yes,
subsection
54, right?
Yes. Charge sheet mentioned 50 subsection 4.
The, apt to refer to rule or section this time? Rule, no, because these are rules. Rule 54 under chapter 9 of section 1, which provides conduct. Which provides conduct. Stop. In as which conduct, sorry, under which the violation of which the petitioner has been charged with, right? So then Rule 54 reads as under, quote unquote, Rule 67, which provides penalties under section 2 of the chapter 9, reads as under. You give whole thing, 67. Here they were given number G, na? F to the other two.
And J
And J for me.
petition.
Reading of the aforesaid Rule 67, it appears that the petitioner was awarded the major penalty of dismissal, which is provided under clause J of major penalty of the list of major penalties prescribed under Rule 67. Whereas the other two employees were awarded reduction of rank under clause F of major penalties stipulated under the said Rule 67.
Lordship, if for these penalties, what is the effect and interpretation that I have already annexed with the writ petition? That can be quoted also if
Where?
page 505.
Page
505.
500.
So this is the letter. This is a e-circular of the bank. And what are the effects they have described for 67G? The relevant part would be 512. 512 for 67G.
Okay.
And for me, it is 515, which dismissal is the harshest punishment. It's written in there.
This is 505.
505 is the letter.
And
And 67G, what the effect it is? It is on 512.
okay.
And for me, it is 515. And then it's written, it's ordinarily resorted to in cases of proved frauds and.
All right, Mr. Das.
I'm just saying the.
All right, I'll fit it. Let me
Please.
see where I'm going to fit this. The issue involved in the instant writ petition being the proportionality of the don't say proper, being the legality and validity of the inquiry come finding dated such and such, and the consequent order of punishment, penalty, comma. The domain of this court under Article 226 of the Constitution of India to go into the validity and legality of such inquiry held by the disciplinary authorities, stroke inquiry officer, is limited. This court, while exercising power under Article 226 of the Constitution of India, shall not embark upon an inquiry, nor shall act as an appellate court and appreciate and reappreciate the materials available before the inquiry officer. Reference in this regard is made to paragraph 13 of the decision of the apex court in the case of P. Gune Shekaran Supra, which reads as under, as here under. Stop. Huh? What crystallizes from the above is that the short question that falls for determination in this writ petition is whether the case of the petitioner was treated differently as that of the other two similarly charged delinquent employees, inasmuch as the petitioner was awarded the most stringent major penalty, while the other two charged delinquent employees were given the lesser major penalty. Undoubtedly, it is the domain of the disciplinary authority to award the penalty upon the delinquent after due consideration of the materials available on record, in accordance with the principles of natural justice, proportionate to the gravamen of the charges, as per the applicable rules. In an event, if this court finds that the punishment so awarded shocks the conscience of this court certainly can interfere with such punishment. In order to test the proportionality of the punishment, the gravamen of the charges is required to be seen. Reading of the imputation of allegations as stipulated in the charge sheet vis-a-vis the inquiry cum finding of the inquiry officer and the final impugned order dated so and so, I have no hesitation to hold that the charges are grave and serious. Now, turning back to the issue of parity of punishments / penalty awarded to the petitioner vis-a-vis the other two charged employees for the similar incident, apt to compare the charges leveled against the three officers, including the petitioner. As extracted herein above, 16 allegations have been leveled against the petitioner for committing serious lapses in performing his job, which, being unbecoming of an officer, the major penalty of dismissal from service was awarded against the petitioner. Charge sheet issued to Ashapurna Singha with the charge sheet dated 11/3/2019, wherein the statement of imputation of lapses alleged against the said employee, as detailed in Annexure 2 of the aforesaid charge sheet, reads as hereunder. Quote unquote, page 3. Gotekeda didiba. এই আশাপূৰ্ণা বুলি যে কৈছো তাতে তুমি কবা can you read that, Pranav? While he was posted as chief manager at Dadra branch of the SBI during the period from 19/9/2017 till date. Till date?
Oh, it was, I think it's transferred. That I'll not know.
Okay. Till the date of issuance of charge sheet. Reading of the aforesaid charges, it appears that for the lapses committed by the said employee in connection with his duties as chief manager of the concerned bank, for which alleged irregular activities, pecuniary as well as reputation loss having occurred, the charge sheet was issued against him. Charge sheet dated 11/3/2019 issued against the other delinquent, i.e. Bhaskar Datta, for his alleged lapses as detailed in statement of imputation of lapses alleged against him while he was posted as assistant branch manager at Dadra branch of the SBI respondent from 19/10/2017 till the date of issuance of charge sheet, reads as under. A2A, page 18. Reading of the aforesaid charges, also it is apparent that the said delinquent was also charged for causing for committing lapses in connection with his duties during his tenure as assistant branch manager, for which the bank allegedly suffered pecuniary as well as reputation loss. Stop. Reading of the efforts, reading of the, no, don't say reading. Upon comparing the charges issued against the petitioner and the two other delinquent employees, it appears that the petitioner was charged of committing 16 irregularities, out of which 12 was proved. Full stop. While Ashapurna so and so against so and so, how many?
There were 10 allegations.
10 allegations were leveled, out of which
6 were proved.
6 were proved. And as regards Bhaskar Datta, Bhaskar Jyoti Datta, Bhaskar Datta, 9 out of the 9 allegations, only 3 were proved. Stop. There is no doubt to the argument made by Mr. Das, so and so, that when the charges are same and identical in relation to one and the same incident, then to deal with the delinquents differently in the award of punishments would be discriminatory. However, before applying the yardstick of parity, it would be necessary to compare the allegations and the standard of involvement of the delinquents so as to effectively adjudicate the issue of parity of punishment imposed upon similarly situated charged employees. Stop.
Lordship, I had this particular point, I think Lordship it's there. I have made a proper chart, like the Asapurna's, which is the allegation, my allegation, whether it is proved, not proved, that chart is made. If Lordship,
Mr. Das, I'm sorry. I am really appreciating your hard work, but you see, it's difficult to get into these areas
no, Lordship,
because at the end of the day, you are right. The main thing is irregularities,
yes.
but your irregularities has to be measured in terms of your job performance.
That's what I.
Anyway, give it.
What is.
Give it. Let me see. Let me see how you're prepared.
Is there also, but still I'm giving it.
Give it.
So both the separately I have done. Me vis-a-vis Ashapurna Singh, me vis-a-vis Bhaskar Datta. Allegation 1 is here, same allegations, which allegation?
ইয়াত এটা চাৰ্ট আছে এইটো তেওঁলোকে বনাই দিছে but I want three things to be together এইটো পাৰিবা নেকি চোৱাচোন মানে তিনজন মানুহ আছেতো তিনটা কলমত লাগে can that be done পাৰিবা so petitioner first Ashapurna and then Bhaskar Jyoti and then proved আৰু যে হেৰিটো আছে সেইটো একেলগে আছেতো so they all proved that proof thing I think
No, what I have done is that since I have separated because in Ashapurna something is proved, in Bhaskar Datta it's not proved.
so what you can I think what we can do is in the 3 columns against whatever is written there in bracket we can say proved not proved
Not true.
isn't it?
Yes, that is also,
That combined list is required.
I can provide his lordship.
You can provide
Yes.
Monday, huh? I'm going to finish the dictation now, but I want that list.
And
You can email it to the court master. You can have the court master's email ID, give it one copy to Mr. Buraguhai so that he can also verify. And both of you can then let the court master know. I want that chart to be part of the order.
lordship, this part also like, no inquiry report with respect to.
That is all right.
And
You
and-
see, Mr. Das, don't get so, you see, that is, you're
No,
not,
Lordship.
we are not questioning.
No, lordship.
Right now, you see, if something is not done for Ashapurna or Bhaskar Jyoti, that will not have any effect in yours. Yours is special.
Yes.
Of course, the parity issue is vital. I'm examining that.
No,
That
I'm
is-
just saying the facts.
That is not before us. Yes. In order to apply, in order to ascertain as whether the gravity of the allegations leveled against the three employees is identical or not. Learned counsels appearing for the parties have jointly furnished a chart which is reproduced hereunder for ready reference. A chart Khondidiba. I think I'll stop it here because now after comparing the chart, I
Yeah.
don't know
Comes out.
what I shall thereafter dictate. Right, Mr. Buragohai? I thought I shall complete, but I think now everything will depend on the outcome of the comparison. Because after comparing, if I find that yes, the gravity of the three allegations are same, identical, then you both know the outcome. And if I find no, as far as the petitioner is concerned, his gravity is more vis-a-vis his duty, then a different outcome. I think only that, isn't it? Nothing much.
Lordship, one submission may be recorded if Lordship will allow, that whatever be the allegations at 10, 9, 16, the end result was one in the charge. That may be written.
Purposely I did not refer to that. You want, I will, because I can
Lordship, I just-
I can dismiss that right away also in front of you, because that is only in that main thing they have categorically said annexure 1. The lapses are detailed. In short, they have said irregularities. But what are those irregularities are set out in the annexures. In respect of you, there were 16, other two, there were less. So I have not gone into that. You are right. The word is irregularities, pecuniary loss, reputation loss. But in respect of what irregularities?
And
The irregularities are detailed.
Lordship, got it. Lordship, that is it. And regarding
You
the
want,
judge-
I can add it.
No. And the judgment, what against the judgment, one submission, I've just read it, subject to correction, what I've understood is that here, which will not be applicable to me because here, all the officers were in the same rank. So someone had done something more.
All
than
right.
that-
Now,
that-
only thing I am posting this matter. I'm closing it actually. You
Lordship,
provide this.
Then Lordship can
Matter to
answer.
closed, huh? Close.
I'll provide the thing by Monday, Lordship.
I would prefer if you can give it to him by mail.
Mail I'll give.
By today, tomorrow, whatever earliest.
Lordship, tomorrow will be a difficult. I'll be.
Day after,
And day after, I'll.
I want to complete it.
Lordship.
You will get the order by Monday or Tuesday, but you give this, huh?
Lordship, there's the chart. The petitioner.
Only the charge, three together.
Petitioner.
And other two.
And below, proof, not proof.
Correct,
That's-
correct.
That's it.
That's
That's
it.
fine.
That's it.
Okay.
You already have it in your
Yes,
computer.
that's
You
why
just have to.
I have to
you know,
compile it.
You have to just do the compiling. তুমি একদম ভালকে হেৰি কৰা দেই এইটো হেৰাব নালাগে তেতিয়ালৈকে তুমি এইখিনি চেছ কৰি দিয়া all right both of you have done very very nicely but of course now
It's the fate of
the court has to do its part
deeply obliged.
Time being item number 5. Number 5 to
কোন আছিলে কোন হয় petitioner
I spoke.
this is the referral matter na Mr. Bhattacharya
This has
Bhattacharya
this
Huh?
has come for the second time,
huh
and I spoke to Mr. R.P. Sharma.
huh
He knows about it, but
why is he not here now the problem is I cannot refer it without the petitioner agreeing
well, off the record, he said that no, he is not willing to refer this matter. But I cannot say that.
None appears for the petitioner. Relist next week on a date to be fixed by the registry. Please record his appearance. D. Bhattacharya, na?
Lordship,
AG. AG, right?
respondent 6.
Huh?
Respondent 6.
6.
Right.
item number 28.
এইটো ইমেইল আইডিটো দি দিব দুজনকে দিব দুজনৰ নম্বৰ লৈ ল'ব Mr. Datta, just 1 second.
Madam.
Eight. 28. Pay parity.
Pay parity basically.
I was on punishment parity, now it's pay parity.
Pay parity.
Yes.
The petitioners, that pursuant to an advertisement in 2010, Lordship at page 19. That about 149 posts of block data manager and assistant district data manager, 27 posts were advertised. Now we are mainly concerned with the block data manager post. And pursuant to that selection process took place, and the petitioners were called for the interview, written test. Lordship will find that in Annexure 2, page 20. Now, they have given some of the notices, but I have not given all. Just one notice I have given. Then, the written tests were held, and finally, the results of the interview was published, and Annexure 5 is the list, Now, the petitioners, of course, were in the waiting list. So, Annexure 5 is the result where the selected candidates were initially appointed. And Annexure 6, page 28.
In 5, you are there.
No, we are not there in 5, we are in 6, This is the waiting list of candidates,
Any relevance?
Relevance because yes, the results for interview for the post of block data manager. So it was with the that reserved for the post of block data manager. We had appeared, and our name were of course in the waiting list.
Your name is in the waiting list.
Waiting list.
Yes.
Then subsequently.
Where in the waiting list?
These names are there. I can point out one by one. For example, page.
How many petitioners are here?
There are 18 petitioners.
Huh?
18.
1-8.
Yes, 1-8.
So all the 18 petitioners are there at page 30.
Are there?
Which are the numbers?
For example, Lordship will come page 29,
Not example.
No, it's just coming.
No, page 25 and lecture 5.
No, page 25 we are not there. Page 28 onwards,
Page 28.
28 our names are not there.
28 is in lecture
6.
6. So your name starts from where?
Yes, I'd start, page 29.
Yes.
Serial number 24.
Yes.
He is, the petitioner number 18, He's the petition number 18. Then,
serial number 39.
Yes,
He's petition number 7. Serial number 41 is
yes,
petition number 11. Serial number 42 is petition number 14. Serial number 44 is the petition number 10. 46 is the petition number 12. Then next page, 47 is the petition number 15. 48 is the petition number 16.
40,
48.
yes.
Then 52 is the petition number
48 is petitioner,
16.
yes.
16.
Then,
Then serial number 52 is petition number 8.
yes,
53 is serial number 1.
yes.
54 is serial number 4.
Serial number 4,
4.
petitioner 4,
Petitioner 4. Petitioner 4.
yes,
Sorry. Well, then 59 is petition number 6.
yes.
Then next page 72 is the petitioner number 13.
70,
2, my lord. 72.
petitioner,
Number 13.
yes.
Then, my lord, 92. Petition number 2. Sorry, 3.
Petitioner 90,
2. Next page, page 32.
petitioner number
3.
3,
It's 92.
yes.
Then petition number 2 is at 102. Serial number 102.
Yes,
Petition number 5 is serial number 104.
yes.
And petition number 9 is at 106. I think, my lord, I have given all the my lord.
P6,
106. My lord.
yes.
Now, my lord, while appointing them, my lord, they make
You are for?
NHM, National Health Mission.
now for while appointing them, my lord, appointment letters are from page 39 onwards, my lord. They were appointed, my lord, as computer assistant, my lord, saying that they were selected as computer assistant.
Page 39.
Page 39, my lord. Onwards, my lord, these orders are, my lord, next, my lord.
Computer
Assistant.
assistant.
Selection is computer assistant.
Yes,
So, my lord, all these persons, my lord, from page 39 to, my lord, page 56
yes,
are their appointment orders as computer assistants.
yes.
No, my lord, their case is that, my lord, initially when they were appointed as computer assistant, they were made to understand that these are the same posts as block data manager, and they were receiving equal salary paid. Then, my lord, suddenly, my lord, there was a direction. Lordship will find at page 74. Page 42. Sorry, annexure 42, page 74.
74. Yes,
5/16, my lord. Order.
yes,
Now, my lord, by this order, my lord, it was decided that the following posts under National Health Mission Assam are hereby discontinued with effect from 10th of January 2017. Now, this also includes, my lord,
computer assistant.
my lord. Then, my
Yes.
lord, the next part, my lord, the respective program officer at state level and the joint director of health services come member secretary of the respective district health society at district level and sub-district level may engage persons for the task on the task rate basis to the extent possible or on outsourcing basis. No new recruitment are to be taken for these positions. Subject to satisfactory performance, the incumbents presently engaged in this post may be engaged in the respective positions on lump sum basis and remuneration may be paid from the approved.
What does it mean?
But it means, my lord, that now they have decided to, my lord, either engage them on task rate basis, my lord, at a lump sum pay, my lord, and, my lord, or outsourcing basis, my lord, or they are to be outsourced.
Earlier you were appointed as computer assistant.
Computer assistant.
And now that post has been?
They say it's been abolished, but they're still working as computer assistants. And as per this, my lord, they are to be, my lord,
Re-engaged.
Re-engaged or something like that. But then there's no re-engagement of us, my lord.
So now what is the dispute?
Dispute, my lord, we are receiving a salary, my lord, that for the moment, though, when we filed this case, my lord, we said, my lord, that the block data managers were receiving around 26,000 per month.
Who is receiving?
The block data managers.
Block
Data
Development
managers,
manager.
Data manager.
Huh? Data manager.
Data manager. Whereas 13, we made a statement that they're receiving around.
So you want the pay of a block data manager.
Because we will always similarly situated.
But
the
your computer assistant has been abolished.
Well, as per
Now,
this,
if
yes.
we go by this,
As per
because
this, yes, ma'am.
this 5, 12, 16 you have never challenged, right?
This is the reason, my lord. We
No, have you challenged 5, 12, 16?
No, 5, 12, 16, we are not challenging.
Correct.
We are
Now,
not
so if we go by 5, 12, 16,
because my lord, for the simple-
just I'm trying to understand, Mr. Datta.
My lord.
Don't get intimidated.
My lord. Sorry.
Computer assistant post
My lord.
has been abolished,
My lord.
right?
My lord.
And it says the respective program officer at state level
My lord.
and the joint director of health services come member secretary of the respective district health society at district level
Yes.
and sub-district level may engage persons for these tasks
Yes.
on the task rate basis
Yes.
to the extent possible or on outsourcing basis. Huh? No new recruitments are to be taken up for these positions.
Yes.
So basically, from the ones who are already manning these posts,
My lord.
they can be re-engaged either on the task rate basis
Yes.
or outsourcing basis.
My lord.
Now, what does this task rate basis would mean?
We don't know actually,
Means
because there's nothing.
an understanding is that you are no longer their employee. You will be a third person as far as their organization is concerned.
Kind of, my lord.
And whenever
Yes.
they need, whenever your task, whenever you are required to
Yes.
perform a particular task,
My lord.
they will engage your services. And for that period, you will be getting something.
True, man.
I mean, going by the language,
That
Mr.
is the
Datta.
purpose. That is the purpose. Yes. ma'am.
I'm only going by the
Yes,
language
yes,
right
yes,
now,
well,
unless
right.
you
Absolutely.
give me some guidelines
Well,
or something.
well,
So it means like that.
Yes, my lord. That is the purpose.
Right.
Well, right.
So what happened after this, ma'am? What did you do after this 5, 12, 16? How have you utilized the services of the petitioners? Because now the petitioners are saying we are performing the job similar to a computer data manager. And so you give us the salary.
We were never informed that we have been now outsourced or we have asked me.
This is there.
No, this is there, but this is not specifically informed to us, my lord. We are
Yes,
not
what have you
issued
done
orders.
to them?
Fresh orders are not issued.
They are paid from lump sum budget.
I'm not interested with what do you pay them.
Yes.
But what have you done
Yes.
post 5, 12, 16?
And the position.
What have you done? Because you see, now they're asking pay parity. Before this court venture into that question, one has to also find out what is the status of these petitioners. Are they regular employees? Are they performing task performance as you indicate? Is that have you taken that post to have been abolished? What has happened? And have you communicated it to the petitioners? These things has to be also answered because you are before now the issue has been brought before the writ court.
Regarding pay parity, my lord, we have.
Pay parity is subsequent.
Yes, ma'am.
Pay parity comes later.
Yes.
But what have you done to these petitioners? Post 5, 12, 16.
Yes.
What has happened to them?
The petition
How
has-
have you kept them?
the petition-
Because based on that answer, the pay parity will now come in. Isn't it, Mr. Datta? I think that is how.
Never communicated anything, my lord, showing that we are freshly appointed or a task grade or whatever, my lord. Nothing of the sort.
Yes.
The petitioners are still continuing with earlier remuneration and which my lord subsequent annual hike in remuneration as per provision of under my lord government of.
Ma'am, you're
India.
not answering the query of the court. You're not answering the query of the court. If you don't know, you can get the records.
Yes,
This
ma'am.
court wants to know how have you treated these petitioners?
Now they are.
I'm not asking a guesswork here.
Yes.
How have you treated them?
I'll file an additional affidavit.
Not additional affidavit. Give us the
And
records.
similar petition is pending under.
Let it be.
Before this annulment or
Isn't it, Mr. Datta? I think the records perhaps would also be required.
Would show, man, how they will. because
How they have treated you.
Exactly, man. Exactly.
Otherwise, how will this court decide the pay parity issue? Are they performing every day? Because this letter says this lump sum is one thing, but how have you treated their surveys? Because initially they were selected, then they were appointed, right? Then you said no, abolished, but task base on outstation outsource basis.
Yes.
What does that mean? Have you implemented that? Because you cannot change their service conditions without giving them a notice. What has happened? Because as on date, are you getting the remuneration of a computer assistant?
That we are getting.
That you are getting. That you are getting. But you are saying that that is equivalent to a computer data.
That way, what we're saying, like the data and a lot of block data manager at the present day, the information is that they receive around 31,000.
So you are asking for
So yeah, we get around 21,000, 24,000 in between.
The increments they are receiving, my lord, as per.
No, but if you have not, you are still treating them as a computer assistant and you have not acted as per the order of 2016, and suppose similar persons doing the similar identical work is getting a higher pay, then of course they may be entitled.
Block data manager gets in different post, my lord.
No, I think a little bit of clarification is required.
Yes.
Because this is not there.
No.
It is the affidavit that has been filed is silent.
On this issue, they're silent. How they have utilized their services thereafter, because
Heard Mr. M. Datta, Learned Counsel appearing for the petitioner. Also heard MS. So and so, Learned Standing Counsel.
Standing up NH.
Learned Standing Counsel, NHM. It appears that though the services of the petitioner in terms of the order dated 5/12/2016 appears to have been abolished and post 5/12/2016 they may be engaged, they may be engaged for the task of computer assistant on the task rate basis to the extent possible or on outsourcing basis. Though pay parity of the petitioners performing the duties of a computer assistant is sought in the instant writ petition on the basis of the appointments as computer assistant equivalent to the persons performing the task of
block data manager.
Block data
manager.
However, in the affidavit in opposition filed on behalf of the on behalf of the respondents, there is no averment or clarification as regards how the respondent have utilized the services of the petitioners post 5/12/2016 in order to effectively adjudicate the issue in hand, i.e. pay parity. It is essential and necessary to look into to be apprised it is necessary to be apprised as how the services of the petitioners have been utilized after their appointment as computer assistant has been abolished. Stroke discontinued with effect from 10/1/2017 in terms of the letter dated 5/12/2016. MS so-and-so seeks a short accommodation to file an additional affidavit in order to clarify the aforesaid query, relist after on such and such date. MS so-and-so shall also have the relevant records available in the court, available so as to available for the perusal of the court if necessary. Okay? You have the records also. Because how will this court decide pay parity without knowing what is the status of the employment? You said these posts are now discontinued from 2017. Then how have you utilized their service? Right?
Item 29.
Yes, Mr. Patwari, you've been waiting for a long time, huh? Yes.
It's always a privilege. My lord, the matter pertains to dismissal of service of the petitioner. And before I start, my lord, the respondent.
Sorry?
The matter is listed for hearing today, Lordship, and it's a 2024 matter. I think for the second or third time it has been listed. So we have not filed our affidavit here, Lordship, and how the records are also been required. Like, Lordship.
You need to file an affidavit.
Yeah, we have not filed our.
This matter is fixed for hearing or what?
Yes,
Yes, sir. Lordship will schedule the order dated 27/5/25.
20?
7/5/25.
2012, it was admitted. 28/5. It says, it doesn't say, oh, for hearing. Right, you want some time? How much time? Heard Mr. J. Patwari, Learned Counsel for the petitioner. Also heard Mr. D. Barwal, Learned CKS Barwal, Learned State Council, State Council for the respondents. It appears that though this matter was posted today for hearing in terms of the order dated 28/5/2025, however, the respondents having not filed return till date seeks a short accommodation to complete the return. Prayer is not opposed. Mr. So-and-so, prayer is not opposed. Relist, yes, when? After? Relist after 3 weeks to enable so-and-so to file return in the matter.
It's just a request, just a copy of the petition I require, because
that request, you make it to Mr. Patwari, he will give it to you. You don't have to make that request in front of me.
Yes,
Mr. Patwari will give it. Any more request?
No.
I think it will come in the orders. Let him complete, or should I say for hearing?
My lord, because by the first order rule was issued, that's why it was fixed for hearing. And as it is, my lord, they are appearing for all the respondents. There is no private respondent here.
Hearing?
Yes.
3 weeks of hearing on DD.
Because for the last 1 year.
Okay.
Supplementary item number 31.
Yes, Mr. Sharma.
No, it doesn't matter because I was in legs in a different court.
No problem.
Yes.
But where is now D. Gogoi? Where is D. Gogoi?
He's coming. A. Suliha is coming.
Okay.
Yes.
What is the issue involved, Mr. Sharma?
Yes, my lord, the issue here which is involved is that we, the petitioners, are assistant professors. My lord, when the matter was moved in the year 2014, we were assistant professors in an Ayurvedic government college. So there was a notification which was issued, my lord, in the year 2010.
Did I hear this matter earlier?
No, my lord, no, no. So there was a notification, my lord, which was issued in the year 2010. That notification, my lord, stated certain increments after certain lengths of time.
1 second.
Yes.
Mr. Chalya, you are appearing for the respondents.
Lordship, Mr. B. Gogoi appears, Lordship. Because of a personal difficulty, had to leave today, Lordship.
You want it on another date?
Lordship will take some time, so Lordship may accommodate us for today, only for today, Lordship. Some accommodation will be.
Tuesday.
Lordship, Tuesday will be fine.
Aspirate for relist Tuesday, but I don't say aspirate for. Heard Mr. M. Sharma, learned counsel for the petitioner, also heard Mr. H. Elia, learned counsel, appearing for the respondents.
Yes.
Mr. H. Elia submits that since Mr. D. Gogoi, learned additional advocate, D. Gogoi or B. Gogoi?
B. Gogoi, Lordship.
B. Gogoi, learned additional advocate general, is handling the handling the brief for the respondents. He having some personal difficulty today, a short accommodation is sought. Prayer is not opposed, released on such and such date. Tuesday. Because it's no point of hearing because then a long weekend. Yes.